Good morning, everyone. I'd like to thank everyone for braving the conditions outside to come down here and join us. I'd like to call the Appeals Board meeting to order. Brendan, you want to conduct roll call?
Board Member Ferris.
Present.
Board Member Little.
Present.
Board Member Sisk.
I'm present.
And Board Member Hess is absent. Thank you.
Okay, let's stand for the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America, to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Those who are going to be sworn in remain standing.
I'll now need to place you under oath. Please stand for your oath. When I complete reading your oath, you please state I do. You to solemnly affirm that the testimony you're about to give in the matters now pending before this board will be the truth, the whole truth, and nothing but the truth. Thank you. You may now be seated.
Thank you. Thank you. All right, will you conduct an agenda review, Brendan?
Yes. Agenda review for December 11th, 2017. The agenda review consists of the following. The clerk of the board recommends approval of the agenda review by the Assessment Appeals Board. The agenda review consists of the following agenda items. Item number 15, application number 1511574, applicant Brittany Miller, continue to January 29, 2018, pending receipt of original stipulation. Item numbers 16 through 18. Application number 16-10322, 16-11251, and 16-11252, 50 East Thousand Oaks, LLC. Approve a stipulation for continuance of applications to February 12, 2018. Item number 24, application number 16-10613, applicant Harabi Incorporated, continue to January 29, 2018, pending receipt of original stipulation. Item number 26, application number 16-10641, applicant Liberty Property Limited Partnership, LTP, removed from the agenda due to the submission of a withdrawal. Item number 27, application number 16-10668, applicant MK RRP 400 National Way, LLC, continued to January 29, 2018, pending receipt of original stipulation. Item number 28, application number 16-10772, applicant James Pierce Enterprises Incorporated, James McBride, continued to January 29, 2018, pending receipt of original stipulation. Item number 29, application number 16-10784, applicant Muller Development Co., LLC, removed from the agenda due to submission of a withdrawal. Item number 34, application number 16-10914, applicant Lowe's as lessee, removed from the agenda due to submission of a withdrawal. Item number 35, application number 16-10985, applicant Delta JC, LLC, continued to January 29, 2018, pending receipt of original stipulation. Item number 37, application number 16-11011, applicant Lois Satori, removed from the agenda due to the submission of a withdrawal. Item number 46, application number 16-11066, Lineage Logistics, LLC, removed from the agenda due to the submission of a withdrawal. Item number 55, application number 16-11135, applicant PR 1201 Rice, LLC, removed from the agenda due to the submission of a withdrawal. Item number 59, application number 16-11330, applicant Daily Arcade, LLC, continued to January 29, 2018, pending receipt of original stipulation. Item number 61, application number 16-11369, applicant Spencer Melissa Thompson Trust, continued to January 29, 2018, pending receipt of original stipulation. Item number 65, application number 16-11469, applicant Peter K. Hunt, Catherine E. Hunt Trust, continued to January 29, 2018, pending receipt of original stipulation. Application number 16-11473, applicant Richard Widmer, continued to January 29, 2018, pending receipt of original stipulation. That completes the agenda review. The clerk of the board recommends approval.
So moved. Second.
Thank you. Are there any members of the public who wish to speak on matters not appearing on the morning's agenda? Any members of the board need to speak? Okay.
Can I have just a second? I'm running into a problem. I don't know what's going on here. motion button?
Oh, okay.
Push the second. Is there a second one? Oh, what's going on here? Okay, hold on. We'll allow you to vote.
Yes.
Okay. Please vote on that item, on the agenda review. There we go. Okay. All right. What on earth? Okay. Sorry, Chairman. So there were no public comments, correct?
Correct.
And there were no board comments?
Oh, Brendan?
That was only two clear items off the agenda. Okay, I believe we can go to the regular agenda now.
Okay, next we're going to review all the regular agenda items. And if you hear your name called, come up, tell us, and we'll take a few seconds to figure out if you were going to proceed or what you want to do, and then we'll come back to you afterwards if you have something to present. Okay. Application 1511125, 11128, 11129, and 1131, Baxter Health Corporation. Is there a representative from Baxter Health Corp?
This was a large value stipulation, a reduction that was submitted to the board. It's over $5 million. I think it's several $1 million of reduction. So it's placed on the board's regular agenda should you have any questions. And it was emailed to you on Thursday, and the assessor is available for questions if you have any.
Anyone have any questions?
No questions.
Okay, looking for motion?
Are we going to approve the stipulation now or just with the package?
The recommended action is to approve the stipulation.
Okay, move to approve.
Okay, please vote. Thank you.
Okay, next item, application 1610932, 935, and 936, Bexalta US Incorporated. Any representative here?
This is related to the last set of applications, a stipulation, large reduction, emailed to the board last week. The recommended action is to approve if the board has reviewed.
Okay.
So
any-
moved.
Thank you.
All right, please vote. Thank you.
Next application 16-10486, 11315, and 11318, Ira Green.
If you want to come forward.
Okay, no problem.
Yes, I want to agree.
Hi, are you prepared to move forward today?
Yes.
And about how long will your presentation take?
I'd say 5 to 10 minutes.
Okay, and do you have copies for the board members in the assessor's office of any, do you have anything to hand us, or do you have any information to give us?
Exhibits.
Exhibits?
I have 6 pages.
Okay, do you have 6 copies of those? 1, 2, 3,
I
5.
have them here.
Okay, do you have copies for everybody?
Yes.
Okay, great.
How many do you need?
Well, we'll need 1, 2, 3, 4, 5.
Okay, I have them.
Okay, great. You will be the first hearing after we roll through the agenda. We'll come back to you first.
Is the assessor ready?
Oh, sorry, assessor's office. Any comments?
We're also prepared to move forward. I believe our case will take 5, maybe 10 minutes.
Okay. All right, thank you, Ira. We'll come back to you. Are you ready? Okay. Next application, 16-10626, Track Tide Marine Corporation.
This was part of the stipulation submitting to you this morning. The recommended action is to approve.
So moved.
Thank you.
And please vote.
Okay, next application, 16-10797, Chris Gulshin. Is there a representative
Okay,
Present.
this is a request. So the assessor had timely initiated a raise request. The applicant subsequently withdrew their application, and the assessor agreed to rescind their raise request, but because the raise request was initiated, the board now has to consent to withdrawal. The applicant appearance is waived pending action from the board. So I have the application, the raise letter, the paperwork if you want. But the question at this time is if the board wants to accept the parties' withdraw and close the application, or require the parties to move forward with the hearing on the assessment.
Okay, any comments from the assessor's office?
Well, at this point, it is at the board's discretion.
Okay.
However, in light of the applicant submitting a withdrawal, the assessor is willing to consent on the condition that the case is withdrawn.
Okay,
Move to accept the withdrawal.
thank you.
Give me just a second. All right, please vote. Thank you.
Okay, next application, 16-10838, Norman J.C. Newman Trust. Is there a representative from Norman J. Newman Trust?
I don't think anyone's checked in for this item. This applicant does live in a evacuation zone of the fire. As such, we'd recommend continuance to an indefinite time, and I will contact the applicant to arrange the new date of hearing once I'm able to get a hold of them.
Okay,
So-
looking for motion.
So moved.
All right, so the motion is to continue, and please vote. Thank you.
Okay, next application, 16-10900, Huss Family Trust. Please step forward.
Hi.
Good morning.
My name's Keith.
Okay.
And I'm here just to request a continuance. It's something me and the appraiser who was working on this, Andrea Rovtar, had agreed to.
Okay, comments from the assessor's office?
We're agreeable to that. We would request that the board order the data be provided within 30 days of today.
Okay.
And if a site check has not been performed, we would like to do that within 30 days as well.
Okay, is there a date in mind?
The available dates would be February 12th, 2018 or March 26th, 2018.
12th's fine with me. And
Okay, looking for a motion to continue to February 12th with a proviso that the data requested by the assessor's office be provided within 30 days and also a site inspection be coordinated within 30 days.
we got a tentative site inspection set for Friday.
Excellent, thank you.
So moved.
All right. And, sorry, can I clarify, was that continuance at the request of the assessor or the applicant?
Both.
Thank you. And please vote. Thank you. I roll call twice just to see if that would fix it. It won't work. Okay.
All right, thank you very much.
Thank you.
Next application, 16-10905, Melissa Lubert.
Wait.
Let's see, sorry. I have a note on that one if I can find it. Yes, she was living in the evacuation zone and didn't think she was going to be able to make it here today. I was able to discuss this with her, and she would like a continuance to March 26th, 2018, and is okay with any conditions the board might put on that, such as data being provided.
Okay, assessor's office.
We would request that the board order the data be provided within 30 days of today. Actually,
Okay.
30 days prior, since it might take her a little bit more time.
Okay, I'm looking for a motion to postpone to March 26th with the proviso that the data be provided within 30 days
Or is it 30 days prior to the hearing?
prior to the hearing.
I think just 30 days prior to the hearing, since she's in the evacuation zone.
Okay. So moved.
please vote.
And thank you.
Thank you.
Next application, 16-11001, Paul and Joanne R. Dworks Trust. Good morning. Can you state your name for the record?
Daniel Wiedenoff, agent for the applicant.
Okay, are you prepared to move forward today?
No, we're going to ask for a continuance. The
Okay.
owner is revoking us as their agent and wants to represent themselves.
Okay. Any comments from the assessor's office?
I think we would still just need the data within
Okay.
30 days of today if the applicant intends to move forward on their own.
Okay, and do we have a date in mind?
We have February 12th and March 26th. I did provide him the dates in advance to check with his client since they will be removing him as their representative. So-
February 12th.
Okay, looking for motion to postpone to February 12th, given the proviso that the data be provided within 30 days of the time.
So moved.
Thank you.
Please vote.
Thank you.
Application 16-11048 through 11054, South Street Center LLC.
This is another request for approval of a large reduction stipulation agreement. This was emailed to the board last week. Recommended action is to approve.
Move to approve.
Thank you.
Please vote.
Application 16-11076 and 11077, CVS Long's Drugstores.
Oh, wait.
What about?
Oh, I'm sorry. I skipped 45. Sorry about that. 16-11058, Evelyn London.
This applicant had a family medical issue that they've reported, and I was able to coordinate a new date of hearing. Recommended action is to continue to April 16th, 2018, which is estimated to be long enough after her family medical issue.
Okay. Any comments from the assessor's office?
We haven't had any contact with this applicant yet. I know from prior appeals, she has issues with some maintenance that needs to be done. So we are looking for data from this applicant. So we would request that the board order the data be provided within 30 days of today.
Okay. Looking for a motion to postpone to April 16th with the proviso that the data requested be provided within 30 days of.
Second.
Thank you.
All right. Please vote. Thank you.
Okay, now on to 16-11076 and 11077, CVS.
Hi, good morning.
Good morning.
I'm Jeff Counter from Ryan LLC, agent for the applicant. We would just like to withdraw these two applications.
Okay. Any comments from the assessor's office?
That sounds good to us.
Was that?
That's fine with us.
Okay. Looking for a motion.
Withdrawals, do we need to?
Do we need
just-
to- do we need
The
a
board,
motion on
Notice.
the board can accept the withdrawal without any action. That's
Okay.
noted for the record.
So no.
Okay. Thank you. Application 16-11126, 11127, 11129, and 11130, Duesenberg Investment Corporation or Company.
These stipulations were submitted to the board this morning. Recommended action is to approve.
So moved.
Thank you. Next application, 16-11132 and 11134, LCFRE Westlake Campus LP.
This is another set of stipulations submitted to your board this morning. Recommended action is to approve.
So moved.
Thank you.
And please vote. Thank you.
Application 16-11222 through 11224, Hypercom Land Comp LLC.
No one has checked in for this item for this morning. The recommended action would be to deny due to lack of appearance.
So moved.
Thank you.
And please vote. Thank you.
Application 16-11351, Michael A. Colo, trustee of Michael A. Colo.
Good morning. My
Morning.
name is Michael Kalau.
Kalau.
And I want to move forward.
And you're ready to move forward?
Yes.
How long will your case take?
Hour to 2 hours?
Okay. Assessor's office.
We are ready to move forward based on the information that has been made available to us. I do want to note that we were denied an interior inspection of the subject property, and we were denied answers to several questions that we had. However, we are ready to move forward. Our initial presentation will be brief. It was a Rule 2 sale. I anticipate submitting additional documentation as rebuttal, so that could take maybe 20 or 30 minutes.
Okay. Now, about the site inspection, will that help your presentation if you have that? I know that's fairly important in what we do.
I believe so. Our appraiser, Mr. Denham, was out there last week. He was allowed to view the outside of the property. The applicant denied entry to the interior. I don't think that he would consent to it at this point. If so, then absolutely we would like a site inspection. But there's issues with the work that was done after the applicant here purchased the property, and
Okay.
whether or not it was solely for remediation or if it was an upgrade or something like that. So without seeing it, we don't really know. But we are ready to move forward based on what we have if he is denying us entry and answers to several of our questions. So
Okay. Any comments from the board?
I have documentation that photography was taken based on my video surveillance of the interior.
Okay. Okay, I guess we will hear your
We
case
can review it
second.
during the time, if that's okay.
What was that?
I have all the documentation so we can review.
Okay, and you have copies for all of us?
Yes, I do.
Okay, excellent. Then we'll get back to you. You'll be the second case we hear.
Thank you so
Thank
much.
you. Okay, application 16-11398 and 11399, Hecken Lively Holdings LLC.
Yes, this applicant lives in a area that was burned. She did come into our office last week, a little distraught, and so we're going to recommend an indefinite continuance on this one, and I will get in contact with the applicant after the hearing in the coming months to reset this once she's had a time to recover from the fires.
So moved.
Okay, thank you.
All right, and please vote.
Application 16-11403, Nahid Nazari.
I'll have to swear this applicant in quickly. Please come up to the podium, and I'll swear you in. Please raise your right arm. Do you solemnly affirm that the testimony you're about to give in the matters now pending before this board will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Can you state your name for us?
Nahid Nazari?
Okay, are you prepared to move forward today?
Yes.
And how long will your presentation take?
I don't have much. It's just, I think I have the copies of the presentation to the board.
Okay.
And I appreciate the time that you're giving me.
Okay, so maybe 20 minutes or so?
Probably less.
Okay. Assessor's office?
the assessor is prepared to move forward. I anticipate our case would take maybe 10 minutes.
Okay, all right, we will hear your presentation third. You want to take a seat? We'll get back to you.
Yeah, the property was purchased in September 2016.
Okay,
And we purchased the property below market
okay,
value.
okay.
And
Right now, we're just going through the whole agenda, and we'll come back to you after we roll through the rest of the agenda, and there's two cases before you. So if you want to take a seat, we'll get back to you.
I'm not sure why I'm here then.
We're
You
just
called
getting
me.
timeframes.
We're going through the whole agenda and getting time frames from everyone
Oh,
who
I
wants
see.
to
Yes, sir.
present their side to us. So we have a few more items to go through, and then we'll go back and we'll hear the cases in order. And you will be the third one that we hear.
Okay,
Thank you. Application 16-11476, 20-10 LLC.
Good morning, Patrick Finnerty.
Hi. Are you prepared to move forward today?
Yes,
And about how long will your presentation take?
5 minutes.
5 minutes, okay. Assessor's office?
The assessor is not prepared to move forward on this case. We haven't received any data from the applicant, so we would request a continuance, and we would request that the board order the data be provided within 30 days of today. And to the applicant, we would request that you speak with Mr. Denham, who is in the back of the room, to
Okay.
discuss what data we need.
Okay. Are you prepared to provide them with the data that they've been requesting?
All the data that's relevant is a matter of longstanding public record. I see no reason to complicate this process any further. It's already a great burden upon me.
Okay. Well, they need data to proceed. So they
So
requesting.
they don't have access to the Ventura County Recorder's records dating back to 2014. They don't have access to the City of Camarillo's planning files. Must I be their clerk?
So we, if I could, we don't know what the issues are on this case until we have time to speak to you, and you can point us in the right direction of what you're basing your opinion of value on.
That was all on the original appeal filing. It's just that simple. You don't go from a valuation established in 2014 of $50,000 to $130,000 in the 16-17 tax year. In the private sector, that would be considered fraudulent.
So
Okay.
this is an appeal, you purchased the property October 27th, 2016, is that correct?
That's right.
Okay, so this appeal is for the value as of your purchase date, and the assessor assigned a value of $130,000. So your appeal is to challenge that, either proving that that was an incorrect value of the property on your purchase date, or that, other circumstances. So you would need to support that with a comparative sales analysis or something similar to challenge the assessment. So that would be the type of.
No, what I would like to see and what hasn't been provided is what the $130,000 valuation is based upon, other than imagination.
You can initiate a request for the assessor's information to obtain that if you haven't already.
I'm ready to hear it now. Why delay? Why complicate a simple process?
That would need to be made in writing to the assessor in advance of the hearing. So we can work out these details if the matter's continued.
Well, let's just hear it today. I'm ready. I mean, if someone puts a value of $130,000 on a property, I assume there's some basis. They must have a big fat file full of quote-unquote data. Let's get into it.
Excuse me,
Well,
Chairman. I believe the assessor has made a valid request for continuance based on lack of data, and it's the board's decision whether or not to continue in response to that request. The clerk has notified the applicant, and the applicant looked this up himself on the assessor's website and on the clerk's website, that the applicant can request information from the assessor regarding the support for the value that the assessor has provided. But the question before the board is whether or not to grant the assessor's request for continuance.
Okay, thank you, counsel. I think we need to make a continuance. We need to postpone this
Yeah,
for some
typically-
time so we can have a data exchange. If you provide them with the information they're requesting and then request their data, they will provide you with their reasoning for the support for the new value.
Okay, so
And-
when that dialogue begins again, I will not once again be told that your representative has no idea what the valuation of the property was based upon?
No, they will be able to provide you their data supporting their reasoning for the value.
So I can walk over to the counter and copy that file right now?
I don't believe so. I think you need to fill out a form and request it. You need to make a formal request for data exchange.
So sworn
If-
testimony isn't sufficient to establish my request?
If I could, we would be more than happy to work with you, and you are entitled to review the documentation that we have and that we based your assessment on. That is a request that you make under Section 408 of the Revenue and Taxation Code. You are more than welcome to go over to our counter and request the basis for your assessment as of the transfer date. If they can't get it to you right when you're at the counter, they will get it to you within 10 days. In the meantime, we would like to work with you on what you believe your opinion of value is and the basis for that, so we can see if there's a middle ground that we can agree on.
Hasn't changed since I filed the initial appeal. It's pretty clear that this is going to be continued, so let's just move forward on that basis.
Okay. Do we have a date?
So the available dates are February 12th, 2018, or March 26th, 2018.
Why don't we include it with the 17 appeal that's scheduled for the January, if I'm not mistaken?
Let me verify that. Okay, yes, that's on February 12th, which is one of our options, so we can
Okay.
consolidate them both to
That
February
makes
12th.
sense.
Okay.
One more comment. If I could, Mr. Denham, who has assigned your case, does have another case going forward, but I believe Ms. Rovtar would be happy to assist you in getting the documentation from us that you're requesting. And if we could
Thank
just
you.
request the data within 30 days of
Okay.
today from the applicant.
All right. Looking for a motion to postpone to February 12th, given the proviso that the data be provided within 30 days.
So moved?
Thank you.
And please vote.
Ms. Rovtar, the one in the back there, she'd be happy to help you.
Let's see, for this next one, I guess it doesn't matter.
Are we ready?
Yes.
Okay. Application 16-11503 through 11510. Rita Rothman-Lessauer.
Good morning, board members. Kent Meyer, Assessment Counseling Services for the applicant.
Good morning.
We're going to request a continuance on this. There are
Okay.
duplicate applications filed by our firm and by Ryan. with
Okay.
The same issues. We want to work it out with Ryan as to who is going to go forward on this. We just started communications with them last week.
Okay.
And we already provided data as far as the lease in place on the property to the assessor when they made the original assessment.
Okay. Assessor's Office.
Well, depending on which applicant moves forward on this, we would just request if there's any additional data that it be provided within 30 days.
Okay. And do we have a date?
So the base, so a prior year's assessment, which would make some difference on how this proceeds, is scheduled for February 12th. So we recommend continuing these to February 12th. In the event that everything's not worked out, we have everyone still here on the same date for the board to resolve the issue, if February 12th is acceptable with Mr. Meyer.
It is.
Okay. Looking for a motion to postpone to February 12th, given the proviso that any additional data required be provided within 30 days.
And is the date acceptable to the assessor?
Yes, that's fine.
Okay, so moved.
Thank you very much.
Okay. Application 16-11512 through 518, 11520 through 11526, and 11528 through 11534. CVS Drugstores.
Hi, yes, Jeff Counter, Ryan LLC agent for the applicant. I am prepared to move forward on these. It's just a request for amendment. It'll take 5 minutes for the
Okay.
presentation. Applications 16-11512 through 16-11518 are also duplicate files with Assessment and Counseling Services. So I wasn't prepared to move forward on those, but it's the exact same issue as the other two, so I don't know if we want to amend them and then postpone them, or just postpone them before we deal with the
Okay.
duplicate filing issue.
Assessor's Office.
Because these were a request for amendment, the assessor is not prepared to move forward on these cases, and we would ask that they all be kept together on the same day.
Okay, so you are prepared to move forward?
We are not,
You are
because this
not,
is a
okay.
request for amendment, and we
Okay.
have 45 days after an amendment to
Okay.
prepare a case.
Okay.
So this is just an administrative action by the board. The applicants, I can pass out a copy of the letter from Mr. Counter. So this is just going to be a simple administrative approval. First, approve. So the request is to amend these applications to, they want to check box A in section 6 of the application instead, which I'm assuming means remove box B1s and B2 on all these subject applications. They're all the same, so I only provided you one copy of the application instead of all of them. But in section 6 on the back, the request is check box A and remove boxes B1 and B2. Unless Mr. Kenner would like to leave B1 and B2, it doesn't hurt to have those marked on there.
No, we don't need those in there, just
Okay.
A, please.
Just A.
And so we need a motion to approve that amendment request.
Okay, looking
So
for
moved.
motion.
Second.
Thank you.
All right, and please vote. All right, and then a continuance would be required since an amendment has been approved. These are related to the prior ones that we just discussed, and Mr. Counter's counterparts of these applications are scheduled for February 12th, so we recommend action is to continue to February 12th.
Okay, Assessor's Office, do we need any more data?
Yes, please.
Okay.
If we could have the data within 30 days, we would appreciate that.
Okay, looking for a motion to postpone to February 12th with the proviso that the data requested be provided within 30 days.
So moved.
Thank you.
Thank you very much.
Thank you.
Please vote. One more, thank you.
Okay, application 16-11573, Angus Hall.
This was part of the stipulation submitted to you this morning. Recommended action is to approve the stipulation.
So moved.
Thank you.
Was there a second to that?
Yes, second.
Okay, thank you. And please vote. All right, thank you.
Application 16-11574, Jeremy Gronstein.
Morning.
Good morning. And state your name for the record, please.
Jeremy Grunstein.
Okay. Are you prepared to move forward today?
I am indeed.
Okay, how long will your case take?
5 or 10 minutes.
Okay. And Assessor's Office?
The assessor is prepared to move forward. Our case will take 5 or 10 minutes as well.
Okay. And do you have copies of exhibits for us?
I do.
You have plenty of copies. Okay. We will hear your case forth. So if you want to take a seat, we'll get back to you. Okay.
Do you want to do the remaining administrative actions, or would you like to return to hearing cases?
Should we just finish out the administration actions now?
All right. So for the hearing officer's decisions, we need a motion to receive and file.
So moved.
Thank you.
All right, please vote on that. Thank you. And then the stipulations, all were provided to your board by email last, I think I didn't get them out till Friday. Recommended action is to approve.
So moved.
Thank you.
All right, please vote. Thank you. All right. And so now we just have the 5 cases left. So I don't know if we need a recess before we get started.
Do we want to take a quick break before we get started? Anyone?
Quick 5.
We do a 5-minute break, and then we'll come back and we'll re-adjourn and start.
All right, thank you.
Okay, we are back on the record. We have one minor housekeeping to discuss. The larger of the 3 trials, Michael Koalo, I think we're going to trail you to the last and let the shorter ones go first. And then we'll probably have time to take lunch break in between theirs and yours. We're thinking, is that, okay, yeah, so you'll have some time. Okay, you're welcome. All right. So, all right, application 16-10486 and 11315 through 318, Ira Green.
Yes, thank you very much. I have 6 copies
Okay.
here of, it's basically the summary of the argument I'm about to make.
Okay.
Okay?
And then, hold on one second, let Brendan hand those out. And who has the burden of proof here?
Travis Ekema with the Ventura County Assessor. I can give the board a brief overview of the applications here before the applicant begins, but it's the assessor's opinion that the applicant bears the burden of proof in this case here.
Okay.
As a non-owner-occupied single-family residence.
Okay.
We do have 5 applications under appeal today. However, the first application, 16-10486, deals with the decline in value for the 2016 roll. And so our case will address the other 4 applications, which are application 16-11315 through 18. These deal with the change of ownership issue that occurred on February 1st of 2011. So we believe it would be best for the board to make a determination whether or not a change of ownership occurred on that date, and then address the decline in value issue after the determination has been made for the change of ownership. So basically bifurcating the hearing for these cases here, so that if the board determines there's no change of ownership, potentially the decline in value appeal filed for 2016 might no longer needed and can be withdrawn by the applicant. So we don't have to waste our time and efforts hearing a case that won't necessarily go forward if the board determines there's no change of ownership in this case.
Thank you. Any comments from the board?
Can I clarify, Mr. Ekema, these are escape assessments? Is that normally switches the burden to the assessor, correct? Is there a reason why these escape assessments wouldn't?
No, actually, Brendan, you're correct. Thank you. The assessor will accept the burden on this.
Thank you, Brendan. Okay, so then Assessor's Office presents first.
And the applicant has not requested findings of fact. Is the assessor requesting findings of fact?
No.
Thank you.
Okay, this will be Assessor's Exhibit 1.
Correction, Chairman, assessor's exhibits are marked alphabetically by ordinance. This would be Exhibit A.
Exhibit A. Yep. Okay, you ready?
Yes, Travis Ekema with the Ventura County Assessor's Office. We'll go over our Exhibit A. I've printed this front and back to save some paper. So on page 3 is our introduction to our hearing packet. The property parcel number is 233-0160-275. The address is 924 Lighthouse Way in Port Hueneme. The assessor issued escaped assessments for the 2012 roll year through 2015 due to a change of ownership event that occurred on February 1st of 2011. There was a grant deed recorded on that day that transferred 14% interest in the real property from the 2003 Wilma J. Green Trust to Ira Green. The trust was for the benefit of 3 children and 10 grandchildren of Wilma J. Green, who passed away on July 7th of 2007. Therefore, when the transfer occurred, it was between children and grandchildren of Wilma J. Green, who are the stepchildren and step-grandchildren of Ira M. Green, the stepfather. The assessor did receive a claim for reassessment exclusion between parent and child. However, that claim form did not list the individual beneficiaries along with the Social Security number, nor was it signed by each transferor, which is required pursuant to Section 63.1 of the Revenue Taxation Code. Therefore, the assessor denied the claim and determined that a change of ownership occurred of the 14% interest that was transferred and issued a supplemental and escaped assessments. On page 4, it discusses the parent-child exclusion. It was approved by the voters of California on November 4th in 1986, also known as Proposition 58. It added subdivision H to Section 2 of Article 13A of the California Constitution to provide that a purchase and a change of ownership do not include the purchase or transfer of 1, the principal residence between parents and children, and 2, the first $1 million of the full cash value of other real property other than the principal residences between parents and children. Section 63.1, which is in our Exhibit D, was added to the Revenue and Taxation Code to implement the parent-child exclusion provisions of Proposition 58 and applies to any purchases or transfers between parents and children that occur on or after November 6, 1986. So this exclusion goes both from parent to child and child to parent. It goes both ways. Okay. There was a letter to assessor issued in 2008. It's 2008-18 is the number, and issued on February 29th of 2008. That provides the assessor with instructional letters to promote uniformity throughout the state in regards to the parent-child and grandparent to grandchild exclusion. And below are select questions and answers that pertain to the issue under appeal today. The first issue is regarding the $1 million limit being tracked. The board monitors this $1 million limitation. The board maintains a statewide database of transferors who have been granted the exclusion for other real property. While not required to do so, county assessors are encouraged to send quarterly reports to the board listing the transferors, their social security numbers, and the assessor parcel numbers, and the excluded value of the parcels on a quarterly basis. The board sends to the county assessors a list of persons who have exceeded the $1 million limit. Therefore, we, the assessors in charge of making sure we acknowledge and keep track of each person that has been the transferor and transferred other real property and need their social security number to do so. A next question that kind of deals with a similar issue here is we have a trust transferring to an individual. And the question is, are transfers of real property through the medium of a trust eligible for the parent-child exclusion? And the answer is yes. For property tax purposes, we look through the trust to determine who has the present beneficial ownership. So therefore, if the requirements of Section 63.1 are otherwise satisfied, transfers to and from a trust are eligible for the exclusion. However, we need to know the social security numbers and individuals of each beneficiary in that trust, and they would need to be able to sign because they would be using their $1 million exclusion limit. And question 50 talks about signature requirements. Who can sign the claim form? So under Section 63.1D, 1A and B specifically requires written certification testing to the parent-child relationship under penalty of perjury from both the transferee and the transferor, or the executors of their estates, or their legal representatives. So a legal representative is one who has been duly authorized and has been given appropriate power. In instances where there are multiple transferees, Section 63.1D, 1D allows one transferee to sign on behalf of the other transferees. They're not using any of their $1 million limit when they're a transferee. However, there is no similar language for transferors. Thus, if there's more than one transferor, each transferor must sign the claim form. Okay. If the property is in a trust, the trustee can sign on behalf of the transferor because the trustee has the legal obligation to carry out the terms of the trust. If the property is in bankruptcy, the trustee assigned to the bankruptcy court may sign the form on behalf of the transferor. In this instance, they don't clarify here, but this is when the trust is for the benefit of only one person. If there's multiple beneficiaries in the trust, each person would need to sign. They need to attest to their relationship. In Section 4, the claim for reassessment exclusion, which we have a copy is Exhibit D, has in Section A that the disclosure of Social Security numbers is mandatory and is required by the Revenue and Taxation Code, Section 63.1. And on that form, it states that Title 42 of the United States Code, Section 405C2, CI, which authorizes the use of Social Security numbers for identification purposes in the administration of any tax. A foreign national who cannot obtain a Social Security number may provide a tax identification number used by the Internal Revenue Service. The numbers are used by the assessor and state to monitor the exclusion limits. Furthermore, in Section B, it requires a certification from the transferors that states the following: that they certify or declare independently perjury under the laws of the state of California that the foregoing and all information hereon, including any accompanying statements or documents, is true and correct to the best of my knowledge, and that I am the parent or child or the transferor's legal representative or of the transferees listed in Section C. I am knowingly granting this exclusion, and I will not file a claim for transfer of base or value of my principal residence under Revenue and Taxation Code, Section 69.5. In conclusion, the assessor received a claim form to exclude the February 1st, 2011 transfer from reassessment, but denied the claim form due to incomplete information. The claim form did not list the individual transferors who would be the present beneficiaries of the trust, which were previously disclosed to the assessor as the children and grandchildren of Wilma Green. And also the claim form, did not list each of the Social Security numbers, or if in replacement of that, their tax identification numbers issued by the IRS. Furthermore, the certification in Section B of the claim form was signed by a single individual, but can't be identified because the name is not printed on the document. To be able to properly apply the law, the assessor requires each individual transferor Social Security number to equalize the $1 million exclusion limit. Furthermore, each individual transferor needs to be able to control the use of their exclusion when transferring property to either their parent or children. Therefore, the assessor requests the Assessment Appeals Board to uphold the change of ownership determination due to the incomplete filing of the parent-child exclusion. The assessor has also attached additional exhibits and made it into a single packet, but we have the letter to assessors, Exhibit B, and this has some frequently asked questions and information and history regarding parent-to-child transfers and grandparent-to-grandparent transfers. The assessor also did attach the blank copy of the claim for reassessment exclusion transfer between parent and child. The assessor does have a copy of the submitted parent-child transfer paperwork. However, there is confidential information on there, as such mentioned, Social Security numbers and tax ID numbers, so the assessor wouldn't want to make that part of the public record, but I do have a copy of it up here if we want to submit that to the record to have it not be a public record. And then the last the second to last exhibit, Exhibit D, is regarding Section 63.1 in its entirety. And the last document we have is the deed that was recorded on February 1st, 2011, in which Michael R. McKinney, trustee of the 2003 Wilma J. Green Trust, granted to Ira M. Green 14% interest in the subject property. So that completes the assessor's presentation, and ready for any questions.
Any questions from members?
Not yet.
Not yet. I have a question. Can they simply amend the application and include the missing items? Is there an option for
that is correct. We had, we sent in November of 2014, we sent a letter to Mr. Green at a Valley Village address saying that we were unable to approve the exclusion because it didn't list all the transferors along with the Social Security numbers and the signatures. So if they provided that back to us, we'd be able to exclude the 14% from reassessment, yes.
Okay.
But I believe in conversations with Mr. Green, which he could discuss, is potentially they're not willing to complete the form for him.
Okay. Any other questions? No. Okay. Do you have any questions of the assessor's office?
I have, well, actually, I do have a question, because when this first happened on February 1st, 2011, the escrow understood that this was after 3.5 years of battling in court over my wife's estate. Obviously, my children and grandchildren were not happy with me. The escrow understood that. The escrow called your office. Actually, I don't think they talked to you, they talked to Mark. And they said that because of the way this is written, they are, at this point, they can give us what we need. Mark said nothing about needing all the grandchildren. Had he done that at that time, they were required by our agreement to do this. So my question to you is, why wasn't this information given to our escrow when it was requested when we first made the transfer? Because at that time, we could have complied.
So you have a lot of hypotheticals in that question that I won't be able to fully answer. Regardless of what maybe a particular staff member in our office stated, the requirement of the law is still clear, and the requirement requires all the beneficiaries to provide their Social Security number and signature because this impacts their $1 million exclusion limit. And so in the future, if they decide they want to transfer property to their children or to another parent, they could be potentially hampered by the situation if it was approved. And that's why the requirement of the law requires each transfer to approve this, because this does impact their future and potentially their future transfers to other parents or children that they do have. And so that's why the law requires each transferor to sign and provide their Social Security number so that everyone's being treated fairly under the law and no one's taking advantage of the law that we have because it is a benefit and we want to make sure everyone's treated equally with that benefit.
Okay. Any questions from the board? Yes.
Chair, the assessor's office mentioned that in November of 2014, they had communicated that if there was an amendment made, that the situation could be corrected. Is that in the packet that the assessor submitted?
No, but I do have a copy here. I can make a copy. It's along with the claim form. So again, I didn't want to submit that for the public record. So it has one tax ID number on there that I could tell, but I don't know whose tax ID number that is. But I can make a copy so we can submit that for the record.
I think it'd be beneficial for the board to receive it into evidence with a redaction, a black mark out of the taxpayer ID numbers, and we can have the assessor just mark that out, and the clerk can go over it to make sure that
we redact any Social Security or tax ID number. So if that's the only stuff that needs to be confidential, that'll be removed before it's saved into the archive of the meeting.
I will make a copy. I'll make a copy for the record and give one to the applicant so he has a copy as well.
With the
redaction, yes.
I would just feel better if the board acts, that the board has that also in evidence.
Okay.
I'm wondering if the applicant received that letter.
I did not. The first letter that I received was February 18, 2015, indicating that they needed another exemption form. And we were told, now this is part of my argument, obviously, and we were told at that time that if we submitted that would handle the situation. And they only asked for the executor of the estate's signature. And we submitted that form, and then suddenly, and they reversed all the escapement. But then they changed their mind and came back and said, no, we need all these other 10 signatures. So you can understand the situation that I'm in, and I'll go through my argument so you really understand why, when he says you can't, someone in his office cannot tell us what to do when we have to have it right. How do we know? And they did it twice.
So to answer Mr. Green's question here, the assessor's office is not a place for legal counsel or give legal advice to taxpayers. We can provide them the documents and the information necessary to help them maybe complete a certain task. But I think when someone asks a question, the details are usually missed because we're not in that situation 100%. As you're aware, my office gets a minimum, in my section in property transfer, minimum 30 calls a day. That lasts about 5 minutes each. And going through the details in each situation to the sufficiency to apply to it, it's just not, the resources are not available to do that. So I can understand Mr. Green's potential confusion about some, but not all the details maybe were provided to staff at that time. We don't know. This was, as Mr. Green said, back in 2011. So this is quite a while ago when this occurred. So, I understand that, but we always tell everyone that they should talk to legal counsel and review the law, because they're the ones responsible, not the assessor, and making sure they're complying with the law and the requirements. And the claim form simply reads the information that's necessary on the form. So it's there and readily available to you, as well as that letter to assessor that's issued. Commonly, we do try to inform the public that there are information available to you on our website, as well as the Board of Equalization's website, because each situation is very unique.
Okay. Any other questions, comments from the board?
No, just waiting on that
Okay.
form.
Should we wait for that form, or should we hear the applicant's
Maybe we could
presentation?
have a 1 or 2 minute break while they prepare
Okay.
the form. They have to redact off the sensitive
Okay.
information.
We're going to take about a 2-minute break and wait for the assessor's office to provide the form to us. Okay, we're back on the record. We've noticed that the address on the form we were just given is not correct. The applicants on the application, they list the address as 5008 Wilkinson, and on the letter we were just handed, it says 5800 Wilkinson. So they
Never received it.
they
That's
never
correct.
received this.
The first communication from you that I received that indicated there was a problem was a letter dated February 18, 2015.
So you-
Requesting a properly filled out form saying that the form of the signature that we used was incorrect. There was no mention at that moment of all these grandchildren, and I don't know when you did the research to determine that, but it certainly had to have been after that.
Just so if we're still doing some questions and answers here, the answer is the determination was made prior to November 19th of 2014, because that's the letter we sent out. It does appear we did send that to the wrong address. It looks like there was a typo there on that address. But if you look at the typo on the claim form that was submitted to us, the typo was actually there to begin with. That was wrong. We put 5,800 when it should have been 5,008. So we did have that wrong in error. But then there was some follow-up documentation that we sent to Mr. Green regarding the escaped assessments and information. I don't have a copy of that follow-up documentation right here, right now. I could potentially get that. Regardless, that doesn't change the point that the claim form is still missing the required information necessary for approval.
May I ask a
Yes,
question
go ahead.
to the assessor's office? Was there any communication between the assessor's office and the escrow department that was handling it?
Back in 2011, not to my knowledge. I wasn't working back in that section at that time.
No
so.
notations in the file or anything?
No.
Okay.
Can I say something?
Yes, you can.
The head of Chicago Title, or the manager, I forgot her last name, Lee Johnson, did talk, she told me who she talked to was Mark, I can't pronounce his last name, at that time, so that they made sure she knew it was critical that this form be filled out right. And she told me that she contacted them. So Travis may not be aware of it, but we worked hard. Also, you mentioned legal counsel. The attorneys at the time that were, I told you it was in court for 3.5 years, reviewed all this stuff. So we tried. But the issue also is, why after 3.5 years do you now come back and ask once again for the wrong thing? Because this letter on the 15th just said that the signature was wrong. It shouldn't have been trustee, it should have been something else. And we redid the form as they asked. And once again, it was denied. And now he's coming in, and then it was after that he then said, we're denying it again because you need the grandchildren. let me also point out that 6 of the grandchildren are Canadian citizens. They're minors. They don't have these kinds of numbers. 4 of the grandchildren were here in the United States. It's a very difficult situation because they believe they were cheated out of part of their inheritance from this court trial. And that's why I said it was critical when we first did this, and this was part of the agreement, that we find out exactly what we need and do that, because at that time we were bound to do that. And we tried. And then we tried again in 2015. It took them 4 years to get back to us.
Okay, thank you. Any more questions?
No.
Okay. I think we're ready to hear your presentation.
Okay.
Mr. Green.
All right, thank you. I wanted to give you some background. Basically, this involves 2 units, 924 Lighthouse Way, and I have the APN number on my form, in 948. I want to just give you an overview because this is really a summary. The 3rd unit was 912. My wife and I in community property owned all of 912. The other 2 were partnerships. The amount that we owned in the other 2 was approximately 1 unit. I think it was 1.02 units or something of that sort. And so what we were doing is exchanging these things evenly. And this was done after this agreement was done after 3.5 years of fighting. And they settled and they agreed to do this. My son is the executor, and he, in the agreement, agreed to fill out the form properly. The difficulty was, I hear now, that you wanted grandchildren who were minors, who did not live in this country, who do not have Social Security numbers. I don't even know what I would have gotten or would have made any sense at that time. This was I see from the deed here, transferred out of the trust, and that's why initially they asked for the trustee's signature, and then they changed that in 2015. Now, the second time around, Travis was involved, and so was escrow once again. They went back to him and Mark to make sure we did the form right this time. They did not ask for the grandchildren's. When it was only after the second form, well, the second form initially was accepted because I got a letter saying that it had been accepted. Then it was denied, and it was only then after it was denied, I was told that Travis had looked back into this and decided that it did not have enough signatures. So the issue that I have here is that we could have complied in 2011, but we apparently did not get the right information as far as what this form needed, and I'm not sure we know today, because do you really want to take an 8-year-old who lives in Edmonton? Does he sign? He doesn't have a SIN number. He doesn't have a Social Security number. The escrow person is Sulu Johnson. She is the manager. She runs the office in Port Hueneme. She took this very seriously, especially the second time. I know she told me she spoke to both Mark and Travis. So I was really surprised when the second one was then denied. And if you look at the dates, you can see it took me a number of months to get my son to sign the second one as they wanted it. So I believe that we worked as hard as we could with the assessor's office. and the executive of the state. I really believe that the second time in 2015 that we did this with what they told us, they did not tell us about grandchildren at that time, that it would settle the manager. Trying at this time to get signatures of grandchildren that I have not seen for like 15 years. They don't know me. I don't see how it's possible. And when I had called wondering what to do, it was one of his people in his office that suggested I file this, that he could see why this would have been an impossible situation, that and I don't know how we could have handled it initially. So when this was first, I want to point out, when this was first transferred, the forms were present. They were approved by that office. The properties were transferred. There was no change in tax. It was only 3 years later, 3.5 years later, or actually longer than that, that we were told that the forms needed were incorrect. And then once, and I know I'm repeating myself, and then once again, they only asked for one signature. So I believe that in this situation, without grandchildren's signature, that you accept my exemption, request for exemption, and ask that the assessments be rolled back to that date. Now, one of these properties has actually been sold, so obviously that would be in your calculation, that, you know, it would stop there. Do you have any questions of me?
Okay, thank you. Any questions of the applicant?
You mentioned that the escaped assessment was reversed.
That's correct.
Do you have documentation?
I
Is that a
don't-
letter?
I would have to try and find that letter at home.
Okay.
I got a lot of stuff, and I kept calling the office there and talking to them, and they were always working on this.
Okay, I'll ask, if I may ask that of the assessor's office?
Absolutely.
Is there a notification of a reversal?
Oh, we're looking into our document storage right now, but I believe there was no reversal that was done. The notice of proposed escaped assessment went out in September of 2016. I believe that was the initial claim that we were doing the assessment. As you see here, what the timeline shows is that in November of 14, we denied it. Of course, we denied it and sent it to the wrong mail address. There was some communication beginning in February of 15 that Mr. Green received, some documentation regarding this. Still no escaped assessment has been issued. Then there was some communication with me in July of 2015, along with one of the other assessor employees in 2015 regarding this issue. So that looks like the timeline, and then eventually, then in April of 2016, we issued the escaped assessment. So it was over 2 years of waiting, trying to get this issue resolved before we issued any escape. So what might be under confusion here, we might have been looking at the information, waiting to issue an escaped assessment unless we received the information needed so that we can properly apply to it. Now, of course, Mr. Green has talked about grandchildren. Well, grandchildren in this case wouldn't be applicable to the parent-child exclusion. Parent-child exclusion, like I said before, goes back and forth. Grandparent to grandchild exclusion only goes one way, grandparent to grandchild. It doesn't go grandchild to grandparent. So the grandchildren could not even sign the form because they wouldn't be a transferor in this situation. So we'd still have to reassess their portion. Now for the 3 children, again, we only have one tax ID on there. We don't know whose tax ID it is. So we'd need the other 2 children at minimum with their signatures to be able to process it. But that'd only be for a portion of it. If I remember correctly, and Mr. Green can correct me here if I'm not, the children were a 60% beneficiary in the estate of your deceased wife, and 40% for the grandchildren, if I do remember correctly.
I don't know, because I was excluded from anything with the will. I was not in her will.
Yeah. So that's the information the assessor had on the some information that there was 3 kids, 10 grandkids, and it was a 60-40 split. So we'd still have to reassess 40% of that 14%, regardless of if the board decided to approve the parent-child exclusion from that standpoint.
So back to the applicant, from what was just explained to us, the grandchildren do not need to sign.
Well, that's interesting. Why did wasn't it, we just said earlier that we needed the signatures of the 10 grandchildren? I heard you say that earlier in this.
Well, what I was trying to say is we needed the signature of all transferors to approve. If they were approved, if they could be approved transferors, they would need to be signatures. But that's correct. If they're not an approved transfer, their signature is not needed because they're not transferring. So their portion would still be reassessed. So potentially I might have not clarified that statement from the beginning. So sorry about that.
I guess at this moment, I don't know what you need. You only need the 3 children?
Correct.
When you have one of them right now?
I believe this is a time for questioning regarding your issues.
Yeah.
If the board has a question for me, or if you want me to clarify that.
Please clarify.
Yes, if you
yeah.
would.
Okay, to clarify, the transfer is the one that is the exclusion is pertaining to. So for example, say you had person A and person B transferring to C, okay? A is the only eligible transferor for the parent-child exclusion. That's where the relationship exists. B would not need to sign because they don't have that relationship. We're going to reassess B's portion to C regardless. So B wouldn't need to sign. A would be required to sign in that case.
Okay.
Okay, I
Go
think
ahead.
counsel.
If I understood correctly, I believe the assessor said there was 1 taxpayer ID provided thus far, but there were 3 affected children. You mentioned that you have not the relationship to go back and get the 10 grandchildren. Do you have the relationship to get the 2 other children?
I might
Social Security number?
I might be able to get, well, you realize I haven't talked to them since probably 2010. It's been 7 or 8 years I've had any relationship. We saw my wife and I saw my oldest daughter, and she is so angry because she believes she got cheated out of inheritance. It's a difficult situation, and the one Social Security number he has is what they asked for, which was my son. He gave it. They know that. They never asked for the other children. What he said to me when he called me, he's talked about all the signatures of the grandchildren. I know I didn't answer that directly. I doubt I could get both of them. By the way, one of them is a Canadian citizen. She lives in Canada, in Montreal. And she's the one that's extremely angry because she lost her home because she expected a much bigger inheritance. So that's the kind of problem I'm facing with this.
Okay, well, yeah, this board's just trying to figure out a way to get this resolved.
I know. I appreciate that.
Can you get the signature from the second child?
I might be able to. I'd have
So
to
we
call
could
her.
have 2 out of 3.
Yes, I might be able to.
And if they understand that this is for their benefit, for the exclusion, so the property taxes are not
No, it's
adjusted.
not. It's not for their benefit. It's for my benefit. See, the difficulty I have is that they believe they wanted to overturn a prenuptial agreement that I had with my wife, and they believe that they were cheated out of $750,000. So when you have that kind of result and you lose, and it took 3.5 years, I mean, when you ask me what my relationship is, it's unfortunate. It's not good. I might be able to get Sheila's signature. I don't know. But once again, if I do that, I mean, I was told in the middle of 2015 when I finally got my son to sign this, that's all that we needed. And suddenly we need more. And that's a problem. how do I find out what do I really need? If it's only that one more signature, I can try and get that.
Mr. Chair, can I ask a question of the assessor? Hypothetically, if the applicant were successful in getting one of the remaining two signatures, would that have a practical effect on the assessment?
Yes, it could, potentially. So the current claim form that we have lists the transferor as the trust and didn't list the individual. So if the individual that signed this, and I can make some assumptions, but of course I don't like to make assumptions. I like to see what the facts are. But I believe it was Michael was the executor. So if Michael added his name up here, provided his Social Security number, if he has one, or a federal tax ID number if he doesn't have a Social Security number, we'd be able to approve his portion of the trust from not being reassessed. But again, here we have 13 beneficiaries of the trust, in which his portion is a small share of that. So we'd have to take that small share and apply it to the percentage we reassess. So the reassessment percentage would go down. If there's two, it would go down a little bit more. If we had three, then it would go down the full amount that it could based on the information the assessor has in his hands at this time. So yes, having one would at least be able to exclude that one portion.
What would be Mr. Chair, if I can ask this question, what would be the position of the assessor's office if the board were to consider the possibility of a short continuance to see if the applicant's able to get an additional signature or not?
One second. The assessor, given the facts and the situation that Mr. Green has, we would have no problem giving him some continual time to have the application form completed, filled out. It's a benefit for taxpayers, and it's a benefit that we like to approve when we have a completed form to approve it. So if we have a completed form, we're in compliance with the law. The state comes and audits us, and they look at the form, and they're like, okay, the assessor's doing their job correctly, and you're not going to write us up for that. That's why we try to make sure these are approved, because it's a benefit for taxpayers that we need to make sure it's equalized. So we'd have no problem giving a continuance for potentially having the document filled out in a better format.
Mr. Chair, in light of the statement of the assessor and the assessor's very gracious acknowledgement that they do want to give the benefit to taxpayer if the taxpayer can qualify, perhaps the board members should discuss whether or not they would entertain a continuance of this hearing for a period of time acceptable to both applicants and to the board, a finite period of time, in order to see if there could be any further benefit gained by the applicant contacting the family members.
May
I ask a question to the assessor first?
Yes.
I just have a question. What would you require from somebody out of the country? I know they're estranged, but what would you require for someone living out of the country?
Yes. So the claim form requires that it's mandatory to provide the Social Security number. However, if they don't have the Social Security number, they can apply with the IRS for a federal tax ID number through the IRS. I don't know if that's the case and how long that would take. I know sometimes people think we take a lot of time, so I don't know at the federal level how long they take on issuing that. But I think it's actually it doesn't take too long from that standpoint. But with that information, then we can report the information to the state so the state can track the $1 million exclusion limit. Because we have to remember, as Mr. Green stated here, this is not a benefit for them. This is a benefit for Mr. Green. And so they're giving up their right to benefit Mr. Green. So at the end of the day, they have the determination to make whether or not they want to provide that benefit to Mr. Green, not Mr. Green. So I think that should be just really important for this board to consider. I have no problem continuing the hearing to allow time for those individuals to make their determination on whether they want to provide that benefit to Mr. Green. So.
Okay.
Can I just add a
Sure.
question? In the form that we delivered to the assessor's office mid-2015, that was through escrow once again, that was signed by my son, and it was his form. So I'm assuming they're accepting that form for him, and I just need another form one of my daughters will never sign it. The other one may. And I would like to ask if when we fill out the form, that somebody look at it and say, yes, if she signs this, it's going to be accepted, because now that's happened to me twice.
So if the assessor could add some clarity. So the current application that we have doesn't state your son as the transfer, so we need his name on there. The second thing, it provides the federal tax ID. And is your son a U.S. citizen?
No, he's not, but he lived in the United States. He has a Social Security number.
Okay.
We actually provided that to you.
Okay, well, that's what we would need it on a completed form. So we need that information on the completed form. We can't complete that ourselves. So what we could do is I can work with the applicant, get him the forms necessary, and have them set up so that we just need the signatures, Social Security numbers, or federal tax ID numbers in this case. Furthermore, we would need the information slightly before the hearing, because we also need to check with the State Board of Equalization, because potentially, and I don't think this is the case, but potentially if they've gone over their $1 million exclusion limit, then we couldn't apply it anyways, because now they've gone over their $1 million and already transferred a $1 million property. I don't think that's probably the case here, but we want to do our due diligence, so we're not coming back to the board and going, oh yeah, we approved this, and by the way, we had to go back and undo it because they went over their $1 million limit.
Okay.
Okay.
So do we have a date to continue to? Are we gonna, are we okay with
Yeah.
continuing?
It depends on how long it's going to take to get the forms executed from out of the country.
Well,
and
it's-
so
Okay.
Yeah, you're right. My son is in Edmonton. The one daughter I have lives, well, again, she used to live in Washington State. I may try and locate her and not even be able to do that.
Right. Well, we want to give the applicant due process.
Yeah, and
So,
Can the assessor
90
give me
days?
any, 90 days, that would be fine. But can the assessor give me any idea if I get both Mike and Sheila's signature on this? How much how much does this change the assessment?
it's, I believe you stated 40% is what was,
Yeah, I think the
Transfer to
initial,
the
our documentation, because when Miss Green died in 2007, there was another parent-child exclusion between Miss Green and the beneficiaries of her trust. So that information at that time showed that it was a 60-40 split between the children, the 3 children, and the 10 grandchildren. I believe the 10 grandchildren had the 40%. So I could go and work the numbers out to show what the potential changes to the assessment would be. There's also the implication potentially on the valuation we put on the property. And depending on those two factors could potentially, there might still be an escape, but the escape might not be at the magnitude that it's at. But I can work with the applicant on trying to get that squared away so that we're able to give the benefit where it's due and then process it in a hopefully an efficient way for him.
Okay,
Okay.
I can
so-
try.
Okay. So do we have a date? Should we, the March or the April date?
I mean, I'd suggest March 26th if no one can put a timeline on how long it's going to take to get everything.
Let's take the April date.
Okay. Was
What's-
that
what is
April
it? April?
16th?
April 16th, day after taxes.
The April is not with this board panel, so I don't know if you would want to could pick this case back up or not.
We should probably pick it back up. That would
Yeah,
save
so we
time.
could do May 7th.
Okay, May 7th.
Does May 7th work for everybody?
okay with the assessor?
Is May 7th okay with the assessor's office? Okay. Looking for a motion to postpone to May 7th with the proviso that the applicant can provide the additional signatures and Social Security or tax ID number to the assessor's office and complete the appropriate forms.
So moved.
Second.
Please vote.
And is that also going to continue the other applications?
So the assumption is that motion applies to all applications for this applicant, and we would revisit all issues at the
Right.
May 7th hearing.
And
Yes.
I'm assuming, do I need a separate form for each child, for the 2 children?
Yeah, Mr. Green, what we'll do after, since the board already made their determination, we'll meet outside and I'll talk with you, get the forms that are needed so we can have them filled out, and then you can have your son and daughter sign and provide their information if they decide to want to have the exclusion applied.
Okay.
So, okay?
Okay, great,
Thank you.
So,
Okay,
move on to the.
we're all set.
application.
Next.
So 64 is going to be next.
Okay. Application 16-11403, Nahid Nazari.
Would it be possible to get the earphones back?
Yes.
I think we should take a quick 5-minute or less break while we're transitioning. Since we have
Okay,
a little-
we're going to take a 5-minute break. Okay, we are back on the record. Who has the burden of proof in this one?
Good morning, Brooke Hill, representing the assessor's office. I think I forgot to say that earlier, so. I believe that when this property was purchased, Dr. Nazari did live in the property. Therefore, we are willing to accept the burden to the extent that we need to prove that it was a Rule 2 sale, and after that, the burden shifts to the applicant.
Okay. So, Assessor's Office, would you like to present first on the Rule 2 sale?
Sure. And if the applicant hasn't requested it, the assessor does request findings of fact.
You do request findings of fact?
Yes.
Okay.
And for the record, Exhibit A has been submitted.
Yeah, Assessor's Exhibit A, sorry. Okay, ready when you are, Assessor's Office.
Yes, Rick Denham, Senior Appraiser, Ventura County Assessor's Office. This is a property located at 978 Blue Mountain Circle. It was purchased on September 8th, 2016 for $760,000. We believe that it was transferred through the multiple listing service. We will have evidence to verify that towards the end of our presentation. That price was accepted by the assessor's office as fair market value on the date of September 8th, 2016. Blue Mountain is I think it's called Braemar. I might be mispronouncing it with my smoky brain this morning. Townhome. It's roughly located off Lindero Canyon Road, sort of near Rockfield, that kind of area anyway. Braemar Townhomes, some of you might be familiar with them. At the time of purchase, the owner did occupy it. She's subsequently left the home, but at that time she did occupy it. If you would go to what I labeled page 3, and for Dr. Nazari, it's this page with all the comparable sales. There are 3 comparable sales from the subject track. 2 of them are model matches, and one of them is a smaller property. We relied mostly on the model matches for value. The model matches sold for $869 and $890. If you do notice, the subject sold for $760, but it was a market sale, so we did accept the price. The next page will show the comparable sales. Those are all 3, even though there's kind of an in and outs, they're all 3 Braemar townhomes, so they're all from the subject area and subject to the same HOA fees, etc. We then have a series of pictures, and they're quite extensive. We start out with the subject listing and showing that it was listed at $789. They did negotiate the price down to $760, and that is the price, to remind you, that the assessor's office did accept sale price. And there's obviously the subject, and then it various pages shows all of the subject and all of the comparable sales. And there's quite a few pictures to sort of clarify everything as you go through. Based upon that data, based upon the fact that it was a Rule 2 sale, based upon the fact that we did accept sale price, and based upon the comparable sales that appear to support that sale price, it is the assessor's office contention that that should be upheld. Thank you.
Okay, any questions of the assessor's office?
Not yet.
Okay, yeah.
I have a question. On the weighting of distance, they're very close. Your comp number 1, there's a number 1 there, and on comp number 2, there's a 0. What is that weighing distance?
I can answer that.
Tad?
So we didn't use that weighting in this analysis. We use those weightings when we're doing more like a Prop 8 decline in value because the sales price falls within the range. As indicated by these comps, we're obligated under Rule 2 to accept that sales price. The weighting, if you could actually see our screen, there it comes up with 2 value conclusions. It comes up with the weighted value conclusion, which doesn't apply in this case. All right.
Were these photos supplied, were they taken from MLS?
Yes, they're
Okay.
third-party photos.
Okay, that's fine, But there's no comp photos for the comparables, right? This is no image on file, and I don't see a...
Let me turn this on. If you look at page 18, 19, 20,
There we go,
and
okay.
on, those are all the comparable photos, front and back, I think.
And
Okay,
just to
thank you.
verify, I use the term third-party because sometimes we find photos that are MLS, and sometimes we find from the internet dated proper time, so we use those.
Okay, thanks. Any questions? Okay, no questions from the board, okay. Ms. Nazari, do you have any questions of the assessor's office?
My question is basically based on the comparable that my agent, the selling agent, provided. This is not realistic comparables that I see on this record that was provided. They're too far away. And I do have also other facts that I need to bring to your attention.
Okay, you'll have your chance to present your case in a few minutes. But any other questions of the assessor's office?
No?
Okay. You can present your case now. Do you have any exhibits for us?
Basically, I do have exhibits that it's provided, and there are multiple facts in this case. One of them is the comparables that was provided, and one of the comparables that my agent provided is the same house that I purchased, and it was purchased like something approximately a year before I purchased it.
Okay.
So that's the price that at that time. So I do not see any reason that difference in 1 year, as the assessor's office provided, goes to from 730,000 to go to a 913,000. That's not a realistic comparison. And my agent, which is very, very eligible person, and they have the highest activity in the market, they have provided the comparison that is more realistic. The second fact that I wanted to bring to your attention is the condition of the townhouse at the time that we purchased it, and there were considerable amount of problems that cost us repairs. So that actually brings the realistic comparison at the time of purchase even lower. And to back up this, I do have the information based on the inspection. There were problems with that, and they did not disclose the problems at the time of purchase. We purchased it, and afterward, we realized that there are problems that need immediate attention before we even can occupy the townhome. And there are some emails I provided as documents, and those are the emails that my agent has exchanged with the inspection owner, Bob Seno, that discloses that such problems existed. Regardless, we had to go through repairs, and that cost us some money even before we can reside in the property. I believe that those facts are overlooked and is not considered by the assessor's office.
Mr. Chair, may I ask a question?
Yes, you can.
Did you actually pay $50,000 for property repairs?
Yes.
Did you get a home inspection report before you bought the home?
Yes, we did, but the inspection was not done right. It was not.
Okay, were any of these items you had to have repaired on the inspection report?
It was not.
Not, okay. I see the date of this proposal is August, and you closed escrow in September. So were you made aware of these repairs before you closed escrow?
I was not aware of it at the time, and the inspection, we actually trusted the inspection, but the inspection came out that they didn't mention them in the report. And as a fact, afterward, I talked to my agent, whose name is Bobby. Mm-hmm. And as you see here, he exchanged some emails with the inspection company and say, these are the problems, you didn't tell us about this. And that's a liability for them because, the selling agent has to let me know if this is not the right value. And as a result of the inspection fault, we were not aware of that. We purchased the house, and then afterward, after the fact, we learned about these issues because of the fault of the inspector.
Okay. Was Bob, was he the seller's agent or was he your agent?
Bobby was my agent.
Your agent, okay.
Bobby Karami, and he provided this analysis. And Bob Seno is the inspector, inspection owner company. It's Seno Inspection.
Mr. Chair, is this
Yes.
applicant's
this would
Exhibit
be
1?
Applicant's Exhibit number 1.
In your exhibit, you have a summary of comparable properties. It's, let's see, how many pages?
Well, there's no page numbers. I have it though here.
6. about the 10th page in. I noticed the sold date, those are all in 2015.
Except one.
Oh, here's one. Okay, the next to the last Blue Mountain Circle. Okay, only one. And the assessor has some more recent ones. Is there any reason why you left out the more recent comparables?
I trusted the agent, the selling agent, and I think he just did a really reasonable work. I don't know about the dates, but I think they're in 2016. One of them is in 2016 for $735,000.
Yes, one of them. Mm-hmm.
And the other one, he wanted to put the same property. I said, why did you put the same property? He said, because, the board probably want to see realistically that this is the same property that was on the market, purchased exactly, not exactly, but approximately a year, and how much of an improvement this property could have made reasonably in the market, besides the fact that, we had these conditions that the seller did not tell us about and the inspector didn't tell us.
Okay, thank you.
A lot of these repairs are things that would be, you would notice in a walkthrough. Did you notice like the cracked wall by the garage, the loose fence? I mean, those are items that are pretty visual. You can identify them fairly easily.
You assume that it's pretty visual, but I'm just my job is in the medical field. I'm not really much experienced in construction or that sort of thing. And I didn't see them at the time. We completely missed them. And I purchased the property based on necessity at that time. I wanted to buy it, and it was available, and we purchased it based on the knowledge at the time we had. If you're doing a good purchase, we didn't know all of these.
Okay.
Did you bring any receipts for your repairs?
I have provided that.
You have provided receipts?
Can I ask a question, Mr. Chair?
Sure.
In the proposal that's dated August 23rd, 2016, it says NRDP Construction proposes to fix all the materials, equipment, and labor necessary to fix all the correction according to provided inspection report dated, and it looks like the date is an August date. There's a little bit unclear there what the date is at the above address. So were these items called out in your inspection report?
No, none of these were in the inspection report, none of it.
How did you understand this to relate to the inspection report when you received this itemization?
This was a independent company that we requested few companies to take a look, and basically this was the more reasonable one that we accepted the offer from.
On your proposal, the first page, you've got changing living room patio door, changing the door. Was the door broken when you bought the house? Or is it just the style? You wanted a different style?
Which item is that?
That's the
Fourth item.
Fourth item down.
The door was in not good condition and it was leaking. It had leaks, so that's what was the reason. Because the contractor said if you just want to patch it, it's gonna, when it rains, it's gonna just happen again. So it's gonna be a cost and then at the end, you have to change it anyway. So it was more, protection, not for the cosmetic reasons, but for, protective reasons of integrity of the house. Then when it's raining, it's not leaking. The water doesn't come in.
Okay, thank you.
Was there water damage by the sliding glass door? Was there any damage to the floor or anything?
It was, yes, there was some, some areas in a corner of the door that it was not really very significant. But then, as I said, my eyes were not the contractor eyes. And I didn't see them as a contractor can see it and say, oh, you know what, this is a sign of water damage. And then they tested it and they said, you see, this water is coming in, so you have to fix this. If you don't fix it, then you're going to look at a much, much more cost down the road.
And then one of the items is patch holes in the drywall and paint. Were there holes in the drywall?
Yes.
Okay. At any point, did you consider renegotiating the sales price? Because it looks like this itemized list was provided to you before the close of escrow. So within that time, there's an option to renegotiate a price based on repairs. Did you ever consider?
No, they didn't. No, I apologize. This is not done before the case. This is saying that, they have the contractor came after the purchase of the home.
Okay.
But I
well,
think this is actually referencing.
It's dated August 23rd.
No, it says, according to provided inspection they have done, they look at the inspection report, and then they did their inspection, and then they provided this. So they actually did whatever, they were just kind of some things that they were in the inspection. They mentioned them here. The other things that they were not in the inspection, they also mentioned it here, if that makes sense.
Right, but again, this is dated August, which is before your property closed escrow. So in the top right corner, it says proposal August 23rd. And then in the first paragraph, it says, it probably says August 12th, 2016. So this was performed before you closed escrow. So you would have had an option to renegotiate with the seller based on a list of repairs.
I do not recall that I did have anything before the close, and I believe that everything was after the purchase. And we did also try to negotiate with the sellers. And unfortunately, the seller agents, they were not professional. And they took some stuff from the property. It was a bad condition, situation that, and I was like, I don't know, buy it, not buy it. But then based on necessity, we went ahead and purchased it anyway. It was not very reasonable condition as you expect in this transaction.
Okay. Any further questions from the board?
No, would you mind if I ask the assessor a question?
Assessors, do you have any questions of the applicant?
You kind of beat us to a couple of them, but as far as comparable sales, you've criticized our comparable sales, and I just want to restate this. All of our comparable sales, not just some, are newer by visa the fact that they're closer to the sale date of what you actually purchased the property. Could you clarify what your criticism is in us using newer comps and not using your older comps?
I haven't seen the condition of these properties that you have put here, and as far as I remember, the comparisons and, when we were purchasing the house at that time, the numbers that you put here sound like really, really far and far away. I never saw any property in that community this high at that time. So it's just really not realistic to me. But as far as the condition of the properties, I haven't seen them. There's no much picture of them that I can see and put, detailed objection to that. But as far as I see here, the prices, the $745,000 is more probably reasonable, closer to the market at that time. But the $913,000 is unreasonable, and I do not believe that I even remember such thing in that, because I have looked at that, community to buy, and I have never seen that kind of price ranging, or the $881,000. It's out of reason and order at that time. Well, maybe there are some owners that maybe the condition of the house, maybe they had much of the update. I don't know what was the condition of those houses, but my place definitely didn't have those, and that has a factor in the pricing for sure. I think maybe that's the difference coming from, because I don't remember anything in that range at that time.
Thank you for your answer. I do want to point out that both of them were closed prior to you purchasing your house. The next question is, did you get a loan on this property when you purchased it?
Yes, sir.
And did a bank go out and appraise it?
I don't remember exactly on that.
And did you get it, if I assume the bank did an appraisal, did you get a copy of it? Did it indicate anything?
I don't have
that
a
you're
copy
stating
of
today?
it. I don't have a copy of
And
it.
as far as you know, the loan went through okay and you were able to finish the purchase, correct?
I apologize?
The loan went through, you got the loan?
Yes, I did.
Thank you.
I did actually, the office requested that from me, and I did try to get that copy in good faith. But basically, the person that provided the loan, unfortunately, he got colon cancer and he's not around. And I failed to, unfortunately, I didn't have a chance to get that appraisal, and I don't have it. But as far as I recall, I don't think anything was extraordinary in the process. My agent said everything is going well. And I believe that the appraisal was in the range of the purchase price, nothing extraordinary.
Any further questions?
Just a couple. Starting with the purchase contract, I believe we had requested a copy of the purchase contract. You didn't provide it, but I just wanted to clarify whether or not you were aware that the contract that I'm sure you used, it's the standard purchase contract that most residential properties would be bought and sold under. It actually says in Section 11C, it says the buyer is strongly advised to conduct investigations of the entire property in order to determine its present condition. Seller may not be aware of all defects affecting the property or other factors that buyers consider important. Property improvements may not be built according to code, in compliance with current law, or have had permits issued. So my question to you is, were you aware of that, and did you, it sounds like you did get a home inspection. What due diligence did you do prior to purchasing this home?
As we did do the due diligence, and we got the inspection, and we got the report. And as I mentioned, and I do have the proof here, that we had significant issues with the inspector. And unfortunately, they didn't do a good job. And I didn't know at the time. I trusted them. And when I believe that this is something that is done correctly, I didn't have any other reason not to at that time. And after the fact, all of these issues came with the contractor, saying that, these are the issues. And I'm not a contractor, I'm not in construction business, and I have no professional understanding of such that I have those equipped eye that if I see, for example, a little bit something in a corner, then I can make a conclusion that these are significant issue to the fact. I trusted the inspector, they failed it. And as a matter of fact, it was too late after the fact.
So the inspection report you got, I didn't bring copies today. I had anticipated you would bring copies of the report, but did you not see in the report where it pointed out all of these defects and all of the cracks and all of the holes in the wall, moisture damage, water stains? I could go on and on. Pretty much everything on your list is addressed in that. Did you review it?
They just basically covered very simple things, and they're not the significant matters. And I think I did email it to you along with the other information.
Yes, I did review it, and it did point out several items that could be addressed. I just had one more question for you. You presented some comparables in your report. Did you take into account any differences, any market condition adjustments or other adjustments for differences between your property and the comparables that you're presenting today?
No, in my opinion, Bobby Karami is the high-selling and agent, and he's very knowledgeable. I asked him to do a neutral job on this. I didn't want to waste anybody's time or my time, and I trust him with the job he did. And honestly, I look at it, I don't see that there's much difference between those properties. Maybe they are in even better condition compared to the facts that I was facing to make this property habitable and, kind of having peace of mind that, to live in this property before, I had to prepare all of those. I think maybe they didn't have those issues even. I'm not aware. But as far as, you look at the conditions and the square footage and everything else, I believe that one of them have even bigger property, like, not the square footage of the building, but bigger backyard than I do. But otherwise, I believe they are pretty good comparables.
Okay, so you didn't look to see if there was a market conditions adjustment, I see. One last question.
I did see the market condition, and I believe that they are comparables.
Okay.
Yes, ma'am.
Were you aware that Property Tax Rule 324 binds applicants and the board to the same appraisal principles as the assessor? And that would require that you make adjustments where appropriate.
I did not understand this. I'm sorry. Can you repeat that?
Okay, so it sounds like you weren't. That's the...
Okay. Any questions or comments from the board?
I'm sorry, I didn't understand what she said. May I ask that she can repeat it?
Property Tax Rule 324 binds applicants and the board by the same appraisal principles as the assessor is bound to follow. Those appraisal principles require that adjustments are made where warranted. That would include things such as market conditions, differences in characteristics, differences for location, views, things like that. I noted on your the documentation that you provided that you did not make those adjustments, so I just wanted to see if you were aware that you are in fact bound to do that.
What kind of adjustments not made?
So in my opinion, there would be adjustments warranted for view, location, market conditions, and other things if applicable, whether or not there were patio covers, spas, bathroom count. I think they were model matches. They were very far in time from the transfer of your property up to about 19 months prior to your property selling. Over the course of that period of time, the market was increasing.
But I believe that the fact that it's overlooked by assessment offices, you did not consider, you just look at the surface and the look of the place. I did the same. But as a matter of the fact, if you want to consider the condition of the property, I believe that there were multiple issues in this property that it was overlooked. I mean, if you look at the pictures only, you may see that, oh, okay, they say that maybe, and the condition of the property is not 100% updated as you are referring to. And I believe that this comparisons are, approximately close to the condition of the house. I don't know the condition, not the condition, but comparables. The condition of these, I don't know how they are because I didn't see them. And I don't know if there's any problem with their bathroom, if there's any crack in the garage. I have no idea. But I know about my property that I did have these problems. And I did have to go through cost of repairs. And, this is what I went through.
I have one final
The assessor has
question.
no further questions.
The assessor's done?
Was that, any further questions?
The assessor has no
Okay,
further
thank you.
questions.
I have one more of the
Okay.
applicant. In your presentation, the 5th page from the back.
Which
says-
page?
The 5th one from the back. It says online valuation analysis, sold listings. And your house is number 2 on that list, 978 Blue Mountain Circle. Can you explain the sold price versus the estimate, the difference there? It says sold price $715. This was the old sale from 2/2015, and the estimate was $833,954. Can you explain that?
Honestly, I believe these estimates from the online, from Zillow, I cannot trust it. It's not really, as I heard from my agent and I was referring to, looking at the properties, he said, you cannot trust the Zillow for any estimates. They're not really accurate. This is what I got from him, but I can't really explain this. I have no idea.
Okay, all right. And I do have one final question of the assessor, if I may. If we can go out of order a little
Good,
bit,
yeah.
is that all right? The PCOR, preliminary change of ownership, did it show a condition checked on it?
I don't know off the top of my head. I can try to look it up if
Okay.
you would like. Oh, I got timed out though. It'll take me a second.
No problem.
It's not working. Let me try it again. Is it this one? I apologize, there's a lot of documents to go through.
I'll bet. Thank you for checking.
The applicant checked that it was in fair condition.
Okay, thank you.
Okay. Any other questions of the applicant? Okay. Closing arguments, I believe it goes to the applicant, correct? Okay, do you have any final closing statements to make?
I just wanted to add that it was a very rough road with the assessment office, and I have gone through a lot of difficulties and unnecessary misconducts, if I can call that I never take any action against as of now. But I think that the assessment office can do a better job in communicating better and respecting the homeowners better. And nobody deserves what I have gone through. I wanted to add that fact that it was a lot of grievance and unnecessary situation that I have gone through. Nobody should go through that.
Okay, all right,
That's
thank
all.
you. Okay, closing statements?
Well, just a couple things to wrap this up. This was a Rule 2 sale. The board has seen the MLS listing. You can see that it was listed in the MLS. It was sold between two realtors representing the buyer and the seller. You can only be knowledgeable about things that are known. In this case, the applicant knew the condition of the property at the time of purchase. Even if she didn't, she was responsible to find it out. The inspection report did point out many defects in the property. Prior to the close of escrow, a bid was received to fix those, and subsequently they were repaired. If items had been discovered after the purchase, it could be looked at as a decline in value. In this case, the applicant was well aware of the condition of the property prior to the purchase. And other than that, as I stated before, we are still bound by appraisal principles. We have two model matches and one other in the neighborhood that sold very close in time to the subject property, confirming that the sales price and the amount paid by Dr. Nazari was in fact fair market value at the time of transfer. And I will let Mr. Denham wrap it up if he has anything else to add. Thank you.
Thank you, Rick Denham. Once again, with the assessor's office. Actually, there were 4 prior notices about condition, if you want to look at it that way. The inspection by the buyer when they went and bought it, the property inspector, which was available and did have a lot of the items she referred to.
Can you refer to those, because
Excuse
I don't
me.
have those.
Hold on.
I don't know what you're referring to.
Can you let them finish, then you'll
I
have a chance?
apologize, because these are
No problem, thank you.
not factual.
They are dated, as the board noted, they are all dated, the condition issues are all dated prior to her purchase. And she did negotiate her price. She did not pay full price for this property. And there were obviously alternate properties available, which she chose not to buy and chose to buy this one. In spite of, and the fourth one is the bank. The bank appraisal would have been very enlightening. It's my understanding that banks don't loan on fair condition properties. They decline them. It has to meet a certain minimum condition standard. That bank went ahead and made the loan. And that answers our questions about condition probably more than anything else, because more than my opinion or her opinion or your opinion, the bank was satisfied with the condition of the property enough to put their money out to make the loan on it. So when you look at these 4 factors, condition has been mitigated. And also the pictures are unclear. They don't support Just as an example, if you look further on page 14 at a picture of the subject kitchen and different pictures, it's obviously that it's not, out and out a terrible home at the time it's sold by third-party pictures. And then further, the comp argument, and I've heard this a million times, and I guess this is 1,000,001, but yes, I did purposely choose newer comps during the time period that the subject sold at. I did not go back and get older comps. And it's our firm belief in the assessor's office that newer comps around the date of sale, and banks, by the way, also do this. I would not see, I doubt if I would see a bank go use comps from 2015 when they had 2016 comps available to them. It'd be a very unusual procedure, and frankly, I was surprised that the real estate agent did that, because I've dealt with a lot of real estate agents, and they tend to take comps that are newer and around the time period of the sale and not look for older ones. So that was confusing to me, and I could see how it could be confusing to the applicant, but it was confusing to me. So when I look at the fully informed about the repairs, or at least 4 different ways to stop buying the property, and it still went through, the comparable sales, and the fact that it was exposed in the open market to her and other buyers, and this is what she chose to pay for it, after negotiating down from the asking price, we feel, and all we did was enroll the sale price, which is exactly what our job is. And for that reason, I believe you should sustain us. Thank you.
Well, thank you very much.
May I answer to the?
Yeah.
I have to add that, I just mentioned what Mr. Denham said. Actually, you do not have the inspection report. I remember that. You don't have it. So I don't know what is it that they're referring to as the inspector provided. And if there is any, please bring it to my attention that what is it that the inspector mentioned in their inspection that you know and I don't know. Number 2 is a negotiation of the price. We did not negotiate the price. I mean, the price was exactly as they're asking, and they put it on the market. They didn't deduct even 1 penny from that price. They put it on the market for $760,000, and that's what we purchased it from. We never negotiated, and they did not negotiate the price. The other issue that Mr. Denham mentioned is the bank appraisal, and basically they did based on the inspection, and they did have a copy of the inspection at the time that they were just had in the transaction, and they did not do the inspection themselves. They just sent somebody, and they basically do the appraisal, but they did not look at the inspection as of the details of the condition of the house. As far as the comps that I provided, there are some comps also in 2016. Maybe a couple of them are older. Yes, I do agree with him on that. And as far as the situation that, I believe that the assessment office at this time, they have been in very bad faith in my case, and I do object to that significantly. Thank you very much.
Okay, thank you. Okay.
Sorry, but I do have to come back with some written facts. If you look on our page 5, the listing clearly states that it was listed for $789. It clearly was purchased at $760, and that is the negotiation that I was referring to.
I did not negotiate that. They decreased the price before even we wanted to buy it. They decreased the price.
Once again, that's the only information I had. And the point is, it was listed higher and eventually had to go lower in order to sell. Thank you.
The seller wanted to sell the property so bad. They wanted to sell. She was actually moving out of the California.
Okay.
They decreased the price. I didn't negotiate that.
Okay, thank you. Okay, any other final comments, questions from the board? Okay. You want to deliberate in the back on that, or okay? We'll deliberate on this in closed session, and we will have, we'll provide our answers to Brandon, and Brandon will notify you of our decision.
I apologize. Didn't.
Okay, we're gonna deliberate on this in closed session, and we'll notify Brandon of our decision, and Brandon will let you know what our decision is.
Do I have to wait here?
Nope, you're free to go, but just make sure Brandon knows how to get hold of you, which I'm sure he
Thank
does.
you very much for your time.
Thank
and
you.
Considerations.
Okay.
Dad, I have any question about your decision? What would be the next step if I
Speak with Brandon.
The assessor has requested written findings of fact, and so when those are issued in a few months from now, those will have the details of the board's decision explaining to you why the board decided how they will decide. So you will get a copy of that.
Okay, do we want to skip to the fourth one?
Oh, it's 12:19. Does the board want to take a break or do the
Want to
next?
do lunch now? We're here the last one, well, I know. It's
I'm
five.
okay
December
with
99.
hearing his case, so you
Yeah.
have to wait through the lunch period if
His
everyone
estimate
else
was-
is.
yeah,
Including clerk. whose Fatigue also needs to be considered.
I can do whatever you want to do.
I say let's try to move through it as quick as we can, efficiently as we can.
So
Not-
the
not
board will
quick.
be hearing item 99 now?
Yes.
Okay.
And then we'll take a lunch break after that and come back and hear the second one.
So Mr. Grunston, if you want to come take a seat up here. So here's the and I'll give you a call as soon as I have the decision, or I know you have my number, you can go ahead and call me if you prefer. Tomorrow. Sorry. Yeah, I'll have an update tomorrow as far as if they've decided or if they need more time and so forth. Let me get them started and I'll answer your questions.
Brandon, there's a funny little sound coming from this. I don't know.
It's probably feedback. What's the batteries? Give me a second.
Okay.
Thank you.
Thank you.
Oh, yes, County of Ventura.
Oh, thank you.
Poor Brandon. I think she's waiting for something.
That is giving feedback. Yeah, okay, so. For this case, the applicant has requested and is currently about to pay for findings of fact. And Assessor, do we know who has the burden of proof in this?
Bought it, do you live in the house, sir?
I do.
Yeah, thanks. Yeah, the burden of proof will be with the assessor's office.
Okay.
Okay.
Initially, once again, this is a Rule 2 case, so.
Okay.
That's that odd circumstance.
Thank you, sir.
We are short one copy. All right, and for the record, Exhibit A has been submitted.
Okay, are we all set, ready to hear your presentation?
Yes, Rick Denham, Ventura County Assessor's Office. Property location is 1631 El Cerrito Drive in Thousand Oaks, California. The property was purchased through the MLS on June 24th, 2016 for $1,855,000. That was what the assessor's office enrolled. That price was established obviously through a Rule 2 sale. The applicant's value as of that date is $1,149,800 as of the time he filled out the application. Once again, similar cases, I think all of them are like this today. We enrolled this price based upon a market sale. You will find a copy of the MLS listing as we go through this after our data, and that's how we established it. This is roughly in the area of the 23, kind of between Westlake Boulevard and the 23, so that would be east of the 23, and not in a fire danger, so I'm glad for that. We'll kind of bring that up as today. And of course, we have lots of pictures in the back of the comparables and the subject. The subject does have a 40,000-foot lot. It's not all usable, and so we did not make necessarily adjustments for smaller comps, and that's just sort of a choice and a habit that we do. We don't want to get into a debate over that, but we did find 5 comparable sales in the city of Thousand Oaks. When you get into larger properties on larger acreages, you do have to stretch out in Thousand Oaks. There's not a bunch of them bunched up together nicely and pretty, so some of our comps are farther away than we would normally like to go, but we also have to be realistic. And so we did use 5 comparable sales, some larger, some smaller, to sort of bracket everything. The subject was a little bit newer than most of our comps, and we did note that. But other than that, they have a lot of things in common in terms of those kinds of things. Here's a map where all the comps are in the subject to kind of set you off. There's a copy of the listing next, which, once again, I will point out in my copy of the MLS, as I did before, the original asking price was $1,945,000, and it was eventually negotiated to $1,870,000 for, I don't know how they got there because I wasn't part of the negotiations, but that ended up being the sale price. And then there's various pictures of the subject property, and inside and out at the time of sale. These are third-party pictures. We do have to rely on them because they were at the time. In lieu of the fact that this was a Rule 2 sale, in lieu of the fact that the comparables show reasonable proximity in terms of value, we brought it in and accepted the sale price, as we do with 99.99% of all Rule 2 sales. Thank you very much.
Thank you. Any questions of the assessor's office?
Yes, it's stated in the MLS, the sale price was $1,870, and yet we're at $1,855.
Not to offend the MLS, because it's a delicate subject with this office. They sometimes don't appreciate our opinion, but the recorder's office did have a slightly different number, and we go by the recorder's office.
Interesting.
I notice you don't have a sale that brackets the sales price. Comp 1 is 1.8, Comp 2 is 1.7, 1.4, and then 1.789.
Correct. In Rule 2, first of all, it's not a requirement, adjusted values. But in Rule 2, it's either the following, within 5% or within 5% of an adjusted value. So it's either or. In this case, it's both. 5% is approximately $75,000, $80,000, and we're within that based on Comp 1's raw sale price. Thank you.
Mr. Chair, can I ask a question? How close were your comps in terms of
They're-
tenths of a mile to the?
Oh, it's marked, if you'll look at distance at the bottom of our form, the closest comp was 0.2 of a mile, the farthest one was 1.8 miles.
Oh, I see it. Okay, thank you.
Yeah, we do put that in.
Thank you.
Like I say, with larger lot, one of the reasons, if you'll note, we do have to note that we were trying to bracket other items besides, we're trying to bracket lot size, we were trying to bracket the size of the home, and in order to do that, like comp number 1 is the only comp we have, for instance, that's larger physically than our house, and so that was probably its purpose or one of its main purposes. We tried to get, I think, comp number, let me get this right, comp number 4 was the only one that really had a larger lot, you know, that kind of thing. We try to, you know, get everything sort of corralled in, as it were. These are, also comp number 1 was also the newest available comp in terms of its year built, which is more similar to the subject's year built. So that sort of demonstrates why we get comps. When we get into more sophisticated properties like this, we have to kind of search for data in a more difficult way. It's not a track home, and they don't fall in our lap like the last one, so to speak. All of those were from the same track. These are custom. Thank you.
Any other questions? Nope. Applicant, do you have any questions of the assessor's office?
I do
in
have
your presentation?
a couple of questions.
Okay.
First of all, thanks everybody for your time and for delaying your lunch. Very nice of you. One question, you mentioned 5 comps. Is the fifth one my house? I only see 4 that are not my house.
Where did I mention 5 comps? I apologize.
I heard that in your.
Oh, I might have made an error.
Okay.
There are only 4 comps. You're correct.
You also mentioned that there were a number that that my house was built is a newer home than many of the comps that you chose. Is that my house was built in 1963? Are you saying that
Its effective age is because of upgrades over the years. We go by effective age, so I apologize for that. That can be confusing, but apparently, probably prior to your purchasing, it had substantial upgrades over the years. And when they are at a certain point, we effectively put the effective year built of the house at that point.
May I ask what the effective year of the build date of my house is, according to the assessor?
It's 2000.
2000.
Yes.
And I will also note that in the MLS, under agent remarks, you'll see that even the agent noted that it had been newly rebuilt 9 years ago.
Okay, so how was the year 2000 chosen, excuse me?
We blend, so it was probably, we didn't pick 9 years ago because they probably didn't, you know, they built substantially most of the house, but maybe not all, so we said, okay, it was updated in 2008, probably with what we knew about this percentage. We said it's probably effectively a 2000 home, and that's how we come up with that.
I don't have that same information, but I thank you for your explanation. One other question. You chose houses based on the distance from 1631 El Cerrito, I assume. Was there any thought given to staying in the same neighborhood?
You know, in a perfect world with a non-custom home, you try to do that. Not all our appraisals when we look at a house, we go, have we bracketed everything? Clearly, I chose one of the comps because A, it was bigger than your house, and B, it was closer in age. And that's what drew me to that house. And ideally, yes, I would like to stay in the exact same neighborhood, so I agree with you. I'm not always allowed to do that, in reality. And sometimes I get none in the neighborhood, so I feel pretty good about this one, to be honest with you.
Those are my questions. Thank you.
Okay, thank you. Any other questions or comments? No? Okay, it's time for you to present your case.
Great, thank you. So, oh, indeed. Oh, copies, of course.
I'll get you a receipt. Probably have to mail it to you because I'm in here, but you can go ahead.
Great.
Okay, this is applicant's exhibit number 1.
Do you have one more copy?
I do. It's mine.
Do you need it?
It's okay, it's okay.
As long as you don't mark it, I can let you reference it.
Okay.
Okay. Don't leave it that.
I won't. Should I get started?
Yes, whenever you're ready.
Great. I'll try to be brief. So my wife and I saw this home in 2016. We fell in love with it. We knew the comps didn't support it. The bank didn't support it, and we went forward anyway. So I just want to be clear, that we knew the price was more expensive than the value of the home. That said, I've been a resident of Ventura County and a homeowner since 2004, and in my previous home, the assessor's office voluntarily lowered the taxable value of my home when that became appropriate. So I wasn't under the expectation that just because the sales price was X, that the tax value was X. That's not consistent with my experience. In any case, as soon as I was able, I called the assessor's office to have an informal discussion about why I thought the value was different than the transacted value. And I got 2 comments that I followed up on. One was, it's a very large lot. It's an acre-sized lot, which is high for the neighborhood. And 2, that it was a recent remodel. And so, as I thought about it, it's true, it is an acre-sized lot, but a big portion of that lot is not accessible to me. There's a fence, and you'll see a picture in that showing that I'm not able to even enter that part of the property because it's a city's culvert. The remaining part of the lot is taken up by the house, the driveway because it's a flag lot, and a nearly vertical, approximately 60-degree incline, which is just not buildable. So it's an acre lot, but the usable portion is taken up entirely by the house. Secondly, that it was a newer remodel. It's true, the house was significantly remodeled between 2006 and 2009. And that said, it was 10 years old when I got it, and we've spent approximately $50K just repairing things. I'm not asking, those are things I was aware of at the time that I bought the house. I'm not asking for that to be compensated in any way. I'm just saying, it wasn't exactly a house that was flipped or built to be sold, I guess I should say. So I chose comps that I believe are newer than the assessor's office. They were all in the 6 months prior to the sale of my home. You'll see those comps there. I also chose comps that are in the neighborhood. I chose the 5 most expensive comps in the 6 months preceding the sale of my home that are in the neighborhood of my home, which is called Conejo Oaks. A very different neighborhood than the assessor's office chose. They chose a property, I'm looking at it this real time, but they chose a property in North Ranch, which is a totally different zip code in terms of value than my home. They also chose a home, the one on Rayshire, which is in a different neighborhood than my home. It's a view home on the hill on the other side of Herbs. I know it because we made an offer on it prior to transacting on 1631. So I guess in conclusion, I don't think the comps support it. You have a record of the independent assessment of the home's value, which did not support the transaction value of the home, and I've given you a couple of reasons. I hope you'll consider them.
Mr. Chair,
Yes?
can I ask him a question?
Yes, absolutely.
On your cover sheet, you had some additional reasons. Could you just very briefly go down the list with any comment you think is appropriate? Because this isn't under penalty of perjury, but your oral testimony is.
Oh, absolutely. So the additional reasons, when I looked at these comps that were, again, within the 6 months prior to the sale of my home, I looked on various websites to understand whether they were in fact true comps. And those comps, those properties were even nicer than my property in the sense that they had either a view home or they had a backyard, which mine doesn't have. They have 3-car garage versus a 2-car garage. You know, those sorts of 1-story versus 2-story, kind of all of the trademark kind of value inflections that a property has. And so I was just trying to make the point that even though the comps are so much lower than mine, in fact, there are elements of those homes that you would think would make them more valuable. And if you look at the bank appraisal of my home, they chose a house on my street that hadn't actually, that was just the asking price that's listed there. It didn't sell until December of that year for something significantly less. They listed it at a 1.7 sales price, and in fact, it was a 1.5 sales price. And that was well outside of the range that the county finds acceptable for choosing comparables. So even if we went with the bank, the number would actually be lower.
Okay, I have a couple of questions. In the appraisal, this was done for the purchase from the bank, right?
Correct.
Okay. So it was appraised at 1.775, did I see?
Correct.
Okay. And then you have $45,000 worth of repairs listed on your page 1. How did you arrive at an applicant's opinion of value of 1.4?
By running the by running the comparables within that same calendar year, the 5 most expensive comparables in that neighborhood.
Okay.
And I should say, if you look at the comparables that I've written down for you on paper here, the reason it says 1.506 instead of the 1.4 is because I didn't realize at the time I was making that list that where I concluded 1.4 that I couldn't use ones that had transacted after my transaction date. So then I had to go back and revise it.
Okay, that's fine. Okay. But it looks like not many of these sales you included have a pool or the pool house.
In fact, the pool house is, in my opinion, a negative because that factors into the price per square foot of the overall property, and it's a pool house. So, you know, the number of bedrooms, the number of bathrooms, and the square footage includes a pool house, which is, you know, obviously not as valuable as if it were part of the regular home.
Right, it does factor into the price per foot, but so does the pool and so do the views, which enhance the property appeal. So yeah, price per foot sometimes can be misleading, especially on larger properties that have more moving parts. It's easier on like when we have model matches and no pools.
There is one model match to my home, and that was the one on La Jolla. That was the same house built in the same year. So you have that as both Mr. Dennon's comp and mine.
Okay, but it also doesn't have the pool or pool house in it. It's not a flag lot. And is it gated like yours? Does it have a gate?
It does not have a gate.
Okay.
Yeah.
So do you think the appraisal by the bank is not accurate because you're still at 1.4 or your?
Well, so I'm at 1.5, having followed the county's directions for the comparables, but, or 1.506, sorry.
Okay.
But the reason I don't think the bank's estimate is useful is because, one, they included houses outside the neighborhood. Two, they included a house where they just factored in the asking price as opposed to the sales price. The sales price was actually $200,000 less than the asking price 6 months later.
Well, banks require an appraisers to put in listings. So it's just a requirement. And usually those listing prices, they get reduced because we know that there's a reduction. And they don't receive much weight in the final opinion of value.
I see.
And the reason he used comps that were outside of the neighborhood, because there's one on like Lynn Oaks, I believe, and one in North Ranch, is probably because they were current. And banks require comps to be within 90 days or 2 or 3 comps within 90 days.
Understood.
Yeah, and it's the assessor's office would not be required to go outside of the neighborhood. Yeah.
I have a question.
Yes, go ahead.
Looking at your photo here, is this culvert actually on your property?
Yes.
It's running on the side, or?
Yes. So on the other side of that culvert is the driveway that you'll see in other pictures, separated by those trees.
And are you showing the power lines up above?
Yeah.
Is that what you're, okay.
Mr. Chair, can I ask a question?
Yes.
What was the property address of the comp used in the bank's appraisal that tied to a listing rather than a sale price that went down by $200,000 when it was sold?
It was on, I believe it's 1643 El Cerrito. Let me make sure that's true. Yes, that's true. It's comparable sale number 5 on the appraisal, 1643. As far as I know, the house that we bought in that neighborhood set the watermark for any house, both in terms of price per square foot and over, actual money spent in that neighborhood ever. At least that's what was explained to us. I feel like we've done a good thing for the city because now, the comps are increasing as a result of our house.
Yeah. Any other questions of the applicant? Assessor's office, any questions of the applicant?
Yes, I do. My first question, you made an offer on a house on Rayshire, is that correct?
That's correct.
Okay. Was that 2016 Rayshire?
Yes, it was.
Okay. Hang on. So you had a chance to buy that home and instead went ahead and bought yours, correct?
Yes, I'm not disputing that I didn't pay the money and transact at that exact price. I'm not disputing that. It's just, as you know, we're not professional valuation people.
No.
We love the home and we wanted to live in it, and I'm not sorry we bought it. It's just.
And I do want to point out to the board that the bank appraiser used that sale from 5/15 apparently. I used the sale from 8/19/16. That's why you'll see a difference. It's my comp number 4, their comp number 2. And you're going to notice a difference in price, and that's because it sold at a different price later on, and I used the latest sale. I'm not sure when the bank used it or had the opportunity. It probably didn't, because they would have done it prior to June, and it falls in the 90-day rule. So, so apparently you would consider that home, or you considered the one you ended up buying, correct?
You know, we were in discussions over the Rayshire home, and somebody beat us to it.
Right, and that happens. My next question is, you had this bank appraisal prior to you purchasing the home, correct?
Yes.
You knew the bank came in at 1.775?
Yes.
But with that knowledge, you went ahead and purchased the home anyway?
Yes.
Is that correct?
Yes, it is.
Okay, so do you think this is appraisal's an indicator that maybe you paid too much? Is that your opinion?
That's exactly what I'm trying to communicate, yes.
Good. Now, let me ask you a reverse question. If a taxpayer came in with an appraisal above what they paid for it, which does happen in the marketplace just like they did, but the seller was willing to sell it and they continued with the purchase, would that taxpayer, should we raise his assessment to the appraisal?
I don't have an opinion on how the county conducts its business. I just don't know.
Thank you. But that's the dilemma we face. In other words, frankly speaking, the taxpayers don't bring in those appraisals to us. But when a taxpayer sees an appraisal and goes ahead and purchases at a price different from that appraisal, and it's in the marketplace, we generally accept that number as a market sale. And I just wanted to explain that's how we got to your price. It's what the market did, because some people have. I bought a house once and the appraisal was more than I paid for it. I bought another house and it was less, and I went ahead and paid more anyway. So I guess that's what I'm trying to communicate.
Yeah, I'm not arguing that.
I'm not trying to argue with you either, but I'm communicating the fact that you saw it and went ahead and purchased it at a different price, in this case higher, and the seller was willing to accept that, and you were willing to pay it. That's where we get the market price, and that's why we value the market price. Also, the fact that you used one of our comps that you actually made an offer of, kind of verifies that comp is similar and should be considered.
I agree.
Okay,
I
because
used
it's
it
the
as
same
well.
buyer. But thank you. That's it. And then I had, no, I don't think I had any other questions. Do you have any questions? I have a couple. Yeah.
So looking at the comparables that you presented today, I'm not sure if any of these are in.
Actually, the comparables, I'll state this before we start. There was only one of the comparables he submitted on my appraisal in the bank. There was only one of those was on either one of our appraisals, if that makes any sense to you.
At the same time or a different point in time?
That's a good question. Which one was?
Pull up.
Yeah, which
Thank
one
you
was
for
it?
that question.
I thought you said La Jolla.
La Jolla. Okay. La Jolla was actually a listing on this appraisal, and I'm sorry. I don't think I used it at all because I wouldn't. Oh, yeah, I did. Or is that the same La Jolla?
La Jolla closed on June 13th of 2016.
Yeah. So the only comp that the taxpayer used that both the bank and I used was La Jolla. Just something to note. And it's difficult. In my opinion, it's a difficult appraisal it was difficult for me. I'm sure it was difficult for the bank. I'm sure it was difficult for the taxpayer. It's a very unique home with a lot of upsides. Thanks.
So just a couple quick questions on this comparable home sheet that you had provided. 976 Jeanette Avenue. I tried to find that address in our database, and I couldn't locate it. Do you know the parcel number by chance?
I don't. The information that you're looking at the information that I put down. I'm happy to do it on my phone. It'll take me a second. But that house is directly behind ours.
So I'm only seeing addresses between 1600 and 1830 Jeanette in our database. And so I'm wondering if maybe it faces a different street or something. I only typed in Jeanette.
I have an MLS number. I wouldn't know how to get a parcel number. Maybe it's on the MLS site?
Well, if you have an MLS listing number, that would give them something to search.
Okay. It is 216-00-2537. Ooh, I found the parcel number as well. But
Let me turn that on. I found it. Let me just write it down real quick. So the property on Jeanette, or if that's how you pronounce it, 976 Jeanette, it sold for $900,000. Did you account for the fact that it is of a significantly lower quality than your property?
no, I've not seen this house. What I accounted for was I think it actually shares a fence with my house, so it's directly next to it in the same neighborhood. And generally, smaller houses sell for a higher price per square foot, and it was the price per square foot that I used for the approximation of my home's value. So I thought I was throwing a bone.
Okay, yeah, I do note here that it's about 1,000 square feet smaller than your property. It doesn't have a pool or a spa, and it's on a lot that's about half the size of yours.
Again, I didn't use the 900,000 for any calculation. It was just the price per square foot.
Okay, that's fine. Let me look here. So for 1480 Reynolds Court, did you make any adjustment for the fact that that property had no pool or spa and that it was only on a 12,000 square foot lot compared to your 40,000 and some odd square foot lot?
Again, the assumption of my lot being 40,000 square feet is a bit of a misnomer, but no, I didn't take those into account, nor did I take into account that house is a single story, which is typically of a higher value, remodeled as well as mine. The lot that it does have is in fact flat and usable and has a backyard, and it has a 3-car garage, which mine does not. So you're right, I didn't take everything into account, not the good stuff or the bad stuff.
Okay.
I chose the 5 most expensive comparables
Okay.
in 2016.
Perfect. So I know what your answer is going to be on this question, but I'm going to ask it anyway. For 1681 El Dorado, our records note that we actually classify property in a pretty detailed way. We'd note it as a quality class 7 and your property as a 9. So that, to me, is a very significant difference that would need to be taken into account. That property also didn't have a pool or spa and is on a lot half the size. So I know your answer. It sounds like you did not take that into account, that it's just accounted for in the price per square foot. Is that correct?
Not exactly. Again, I chose the 5 most expensive comparables I could find, and newer than the ones that you've chosen. And I don't know how to. I would love to choose something even more expensive, but there aren't. They just don't exist. The house set a high watermark. But I appreciate what you're trying to say.
Right. And it looks like all of the comparables, maybe with the exception of 1480 Reynolds, were built in 1963 and didn't have nearly as, even if they were remodeled, it wasn't nearly as expensive as the remodel on your home.
I don't know that. I don't know that anybody knows that to be the case, but my house was built in 1963.
Okay, no further questions from the assessor. Thank you.
Okay. Any other questions of the board? Okay. You can present your closing arguments now.
So in closing, I guess I would say, 1, I chose newer comps than did the assessor, and I chose comps that are within my neighborhood, which is Conejo Valley, the first neighborhood to be built on in Thousand Oaks. It's significantly different than other neighborhoods. And third and finally, I feel like the 1 acre lot is not fair to be described as such because I don't have access to most of it. That's it.
Well, thank you. All right, Assessor's Office, you can make your closing statements.
Thank you, Mr. Chairman. As noted, this buyer was very well informed. He had a full bank appraisal telling him what they thought the value was. He had obviously prior knowledge in the area because one of my comparables he had actually considered buying, which by definition makes it a comparable. It's, would this buyer buy this house or this house? And the answer here happens to be for sure yes, because he actually went and saw it and considered it. I would note that that's my comp number 4, and I would note that the sale price when it finally did sell in August of 16 was within 3.3% of what he actually paid for his house without adjustments. And that sort of hits our 5% rule in and of itself. And yes, sometimes in the marketplace, the highest sale in the neighborhood is purchased by somebody, because in order to have the highest sale, somebody has to buy it. In order to have the lowest sale, somebody has to buy it. And the point of the marketplace is that it's going to have different kinds of sales, but somebody does have to be the highest, and it's still a market sale. And it has to be the lowest, and that doesn't mean they bought it below market. That's just what they paid for it due to circumstances. Also, I note the bank appraisal also used the comp on Rayshire, meaning that 2 different individuals kind of looked around and said, what's this house like? I also note there's no adjustment made by anyone in terms of the lot, in terms of square footage against other lots, because they do account for the lack of, lots are 2 things. They are utility, so we'd like them level. Level's better than not level. That's true. But they're also privacy. Some people, when they have 40,000, they have control over personal space of 40,000 feet versus, 9,000 feet. Both of them might be equally level or have equal utility, but the control, usually it favors the bigger one. In this case, we sort of gave up that favor and said we're just not going to make an adjustment. We did find a couple of lots that size to kind of, what did folks that did buy that lot size, what did they have to pay? And it seems to be similar to what this gentleman had to pay. So we had a fully informed buyer, we had a full market sale, we had a negotiation of sale price, and The assessor's office then accepted that sale price. That is by definition what our job is. And that's my conclusion. Thank you.
All right, thank you very much. We will deliberate this behind closed doors, and we'll notify you of our decision when we have it finished. Thank you very much.
Thank you very much.
Thank you, and I think it's lunchtime. Should we
I think the gentleman
return?
just came back.
I know. Sorry, it's taken us a little longer than expected. Shall we return here at 1:45? Give us like 40 minutes roughly? Okay. Adjourned.
Not adjourned, recess.
Recess, sorry, recess. Got ahead of myself there. Are we all ready? All right, we're back in session. Application 1611351. Who has the burden of proof in this case?
Brooke Hill, representing the assessor's office. This is also a Rule 2 sale, and it is an owner-occupied single-family residence that qualifies for a homeowner exemption. Therefore, we believe we have the burden of proof only to prove that it was a Rule 2 sale, at which point the burden would then shift to the applicant.
Okay, so applicant has the burden of proof? Or?
So we have
Sorry.
the burden to prove to you that it was a Rule 2 sale.
Okay, that's, yeah. Okay, okay, would you like to proceed?
And clarify, the applicant is not requesting findings of fact. Is the assessor requesting findings of
Yes,
fact?
please.
Okay, counsel, the assessor's requesting that.
No, next. We'll tell you when. No problem. Okay, you may proceed. Thank you.
For the record, Exhibit A has been submitted.
Okay, whenever you guys are ready.
Thank you, Mr. Chairman. Rick Denham, Ventura County Assessor's Office. The property is located at 1109 Calle Las Trancas, and that's in Thousand Oaks. Basically, it's known and more popularly in the real estate world as Lynn Ranch. And the property was purchased on August 19th, 2016 for $1.1 million. This was done through the multiple listing service. You will shortly see a copy of the the listing. And that price was subsequently accepted by the assessor's office as fair market value. We can move on to my comparable sales. In this case, all the comparable sales are located in Lynn Ranch, as is the subject. Probably the biggest distinction of the subject compared to most of Lynn Ranch is that it was built slightly newer in 1990 than the majority of the homes, which are mostly in the 70s. And other than that, it had swimming pool, which is actually usually more popular, but I was only able to find one comp with a pool. It's typically a pool area. The lot size is typical, although there's two distinct groups. There's lot sizes over 20,000 and under. I only used one comp with a larger lot, and my adjustment is basically not really square footage, but based on the fact that you can have animals on that lot and different varieties. And I used that particular comp because it was one of my comps with a superior view, and also had a pool and spa, which was important to me because my other comps didn't have that. But all the comps, like I said, are basically from the subject area, and which, as I said, is known as Lynn Ranch. Once again, we accepted sale price of $1.1 million. There's a comparable map that kind of shows you where they're laid out. And if you know anything about Lynn Ranch, it kind of meanders up and down. There's a copy of the listing showing listed price and what he paid for it. Various backup documentation about the subject property, and third-party pictures of what the subject looked like the day it sold. And also third-party pictures of the comparable sales and what they looked like the day they sold. So, and those are in the back. They tend to be, I think, the subject is mostly up to page 22, and then after page 22 tends to be the comparable sales. So that's what you have. Once again, I will remind the board that being a Rule 2 sale, either adjusted value and or sale price have to be within 5% after you adjust, or actual sale price. The effort by the state of California in terms of accepting Rule 2 sales is very much present. We have to have a gigantic reason not to take the sale, and it has to be very substantial. And so far, with the data we haven't seen that. And so that's why we came up with $1.1 million and supported our initial acceptance of sale price. There may be other materials presented, and we may have later on, besides this, to present some other materials. So I want to make the board aware of that,
Okay.
depending on how things go, so to speak, we may submit additional data. Do you need anything? All right, thank you. That's basically our presentation. Thank you.
Okay, any questions from the board? Do you have any questions of the assessor's office for their presentation?
No, I'm sure I'll have questions during the
Okay.
process, yeah.
Okay, I guess we're ready to, you can make your presentation now. You can hand your stuff to Brandon and he'll distribute it to us.
Packet A and a packet B.
You want them to have everything right now?
Yes, please.
Do this and I'll come back around
No
in a
problem.
second. Do you have a 6 copy of that?
Yeah, you said there's only supposed to be 5, so I just kept one here.
You had to hand over 6 copies.
Okay. Would you like a
If
6th?
you need it to reference, you have an extra where you can give it to me and still have it for your.
I just brought 6, and I saw there was 5, so I was just going to hold the 6 and use it as reference to walk them through. If not, then I'll give them to you. It's fine with me. It's up to you if you want them.
We can share. We'll just let Brendan have one.
Okay.
Brendan, we can let you have one and we'll share.
I can give this to you guys if you want it.
It's okay, we got it.
Okay.
For the record, a binder labeled Packet A has been submitted to the record. We will mark that as applicant's Exhibit 1, and a binder titled Packet B has been submitted. We'll mark that as applicant's Exhibit 2.
Okay, whenever you're ready.
Much appreciated, Board and County Council. Can you guys hear me okay?
Yeah.
I guess I'd first want to just, before going into details, open with the foundational structural issues that were not disclosed after I purchased the house. and there's a lawsuit which will go through. That wasn't disclosed. So based on Rule 2, I believe that doesn't apply for what they're getting at. So I want to put that as a note and a question, I guess, back to them to that point. So we'll start off with that. So getting into the details, two things. One is kind of walk you through the documents that are here and kind of go through that process if that's okay. And a couple things is noted, like last time I asked the question about if these are recorded and they're transcribed, and the answer I got back was yes. So I just want to verify that that is true. This is recorded, broadcasted. Appreciate that. And the reason why I ask is we'll go into the NDA that I signed during the lawsuit that I had in this case.
Okay.
And the other thing, too, is I know going through some of these details in regards to allowing the assessor's office to come in and stuff like that to the house. I contacted them numerous times. Never got any contact back, but they did contact my real estate agent first, and we'll go through some of that as well. So I'll kick off by saying that, I have presented to the assessor's office a breakout of all the costs paid to date, the filing of my mediation, and other detailed list of a cost to cure for damages. I've also given them any and all documentation that they have and I can legally give based on NDA that I signed with the selling party to Section 441D of the Assessor's Handbook, not withholding any information. I also did a 1606, shared everything you guys see here today with them as well. I'm open and honest. I have nothing to hide when it comes down to this. So one thing I did ask was for the assessor's office, if you wanted me to disclose the information of the NDA of the lawsuit with the numbers, that I would have to get information from you guys signing off on all waivers, that if I get sued, you guys are responsible for it, and I never got answers back on that question. So if you guys would like to sign something along those lines, I can share the numbers of the lawsuit, the case that I won against these individuals. And I do have documentation, which we'll go through as well in here. I'm going to walk you through that in a moment.
This is a public hearing, and I cannot advise any of the board members to sign anything accepting any liability for taking in information and evidence. You're the master of your case. You present what you believe you need to present, but I cannot advise my board members to sign anything taking on any liability for reviewing records during a public proceeding.
Much appreciated, County
Thank
Counsel. Yeah, I just want to make that known because I can't, based on my NDA, share those numbers unless that's bi-directional. So I'd like to give you, County Counsel, I'd like to give you a little bit of history. Let's see. My wife and I, Dana, purchased the home, as Rick stated, in August 19th, just 5 months after being married, right over here, Channel Islands, which was pretty awesome. This is going to be our forever home. Born and raised here. Parents have been here 43 years, the whole 9 yards. So live and die by Ventura County, as it states. So we'll fast forward to the purchase and the aftermath of what happened and the timeline and the details, which I'm going to outline after the table of contents. It all started when we took ownership of the property, and I noticed that the front of the hillside was dead and lacking of water. And we came to find out that the gardener was fired about 45 days before the close of the escrow. All the notes and the audio files have been shared at the beginning of this trial for them, and they've had access to it. We continued into the house and noticed that the floorboard in the living room was warping. Since I knew that replacing a floorboard is an easy process, I removed the floorboard, and you'll see this in the documentation with the lawsuit. To my chagrin, I saw black spots that appeared. We then contacted the realtor, and I got a name of a mold specialist who's SOS Mold, who's the owner and is a PhD. That came over the next day. Based on the reports you'll see in Packet B, tabs 1, 2, and 3, which we'll review, it classifies that the mold in the rooms was extensive. So during this process, we thought there was a big health issue and stuff like that, so we had to get rooms quarantined when we came into this house, right? All of this stems from, you'll see once we go through the lawsuit, that he decided not to disclose the damages of the house, because you have to disclose within 3 years, and he did not disclose the information of those 3 years, which came up in the lawsuit and deemed in my favor. We became scared, feared for our health, and we decided to get education on this, figure out what we need to do. So we contacted a lawyer. It was a long process. It took very many months. Evidence and a quote to a cost to cure, like for like, equal or lesser cost replacement. So in order to gather evidence and to prove that that any knowledgeable, willing, and able buyer, bless you, buying this house would not have paid $1.1 million for this home. If he would have disclosed the information about the lack of the mold, the paint that he did to cover up, hence the lawsuit of this, I would never have gone in and paid the $1.1 million for this house. So we went to our neighbors, found out some of the details and some of the facts, which you'll see in tab 6, which we'll review in a moment as well, disclose the information that he did lie and he did cover up the house with the tarp when it rained to not have the mold fester even more. Even more came out in December and January when we had those hard hits of rains last year, if you guys can recall, that we had. The flooring in the master, flooring in the kitchen, pretty much the entire house was a wreck. The cost to repair far exceeded the price to replace some of the floorings and some of the other things that were in there based on the stuff that was there. We had, as you'll probably see in some of the stuff that Rick and team will share, that we had hardwood floors. And if you want to replace hardwood floors, it's very expensive. So we went to a cheaper, lesser route to put in because the cost of that type of flooring was over $15 per square foot. And you'll see some of the details. We went to a cheaper tile at $4.95 a square foot, right? Because I can't afford based on the payment that I made on this house. So what I want to do is I'll walk you through. If you go to the table of contents at the very beginning of the first page, you can see and I'll outline the kind of the chain of events. I think understanding and knowing some of this, because this appeal is based on a base year. And as noted a moment ago, as the assessor wants to do a Rule 2, this shouldn't apply because of the fact that there was no disclosures made on this property that should have been made. So looking at this timeline, going to the next page, you'll see when we purchased the home, you'll see the timeline we're at till today. The lawyer was engaged. A couple things. You can see that the stress happened. My wife got Bell's policy. We got a cost to cure start. We started the deposit in November. So we had to live in converted living quarters, which was a third-car garage that they converted. Had no refrigerator, had no oven, had no amenities. For a year, we had to eat out. Work continued, rain stalled. February, we filed the appeal assessment, understanding what we needed to do next. We went to mediation, signed an NDA, which you'll see in tab 5, which we'll review after, and waited for the assessor's office to reply, sent voicemails, responses. You'll see in tab 7 the detail of every email that was sent and the details moving forward. We've been on fertility, had a miscarriage, did more stuff with the assessors, had a second miscarriage. We're now over $40,000, $50,000. Thank God in October, we finally started boxing things back up. I apologize, you guys. And then we finally moved into the house so we can actually call it a home. Just in November, just recently. So you can see the events over there verifying that, you see the name over here, my real estate agent. Contacting them in the threads I asked, they say, we just got a call from Rick, and they asked me, he wanted to confirm the tragedy that you guys went through, and we did, and you can see the email, the text messaging thread that went back and forth. If you look towards the end, when I answered his question, he told me that it confirms exactly what was said and what I've said in emails and documentation to the assessor's office. A couple other things on the next page, you can see entering property without permission. And we'll go to tab 7 in just a moment. So the house, because of being vacant, right, we want to make sure there's no vandals and stuff along those lines. So we put stickers on windows, and we still have it to this day, video surveillance along the premise of the property. There's noted, and you'll note, and I'll skip over to tab 7 in just a moment after I view this one page, that Rick contacted me and wanted to come see the house. I was on business travel that week. I didn't give them permission because with my contractor, he needs to know who's on the property, when they're on the property, because he's liable if someone gets injured or hurt. And in that case, you can see in the footage, and there'll be more details in tab 7, that I was not home, nor was my wife, and he still entered the properties and took photos and pictures of it, and you'll see bigger pictures in tab 7 in a moment. So he has documentation of the house as the state as it was being cost secured and repaired for all the damages. And you can see him on the next slide looking down at the camera. The email communication, which is there, you can see we can follow along, right? Trying to contact them, just doing a follow-up, anything happening, what's going on. I don't know what some of the next steps are, so forth and so on, as you can see in the next slide. So the next is going to go into, I'm going to go through these descriptions, and I want you to review some of the tab 1 in a moment. But you can see some of the details of the mold. That first picture on the top shows the mold that we saw at first. And when the individual from SOS Mold came over, said, you should get out of here, this is black mold, and you can read in packet B the details of the mold, in which we had to then quarantine the room, quarantine the dining room. As you see below, that wall that's there deteriorated, the outside deteriorated one of the supporting structured beams. As I mentioned earlier, right, foundational issues, structural issues that needed to be repaired based on cover-ups that this individual did and did not share with me. There's photos of my office, photos in the kitchen. I wish pictures are clear. I wish I can blow them up and actually put them on the screen right here, because I do have them on my laptop, of the extensiveness of a lot of these pictures. When you see this, I hired a professional photographer to take images of this because of the rippling in the ceiling and stuff along those lines. We were only allowed to enter the house at basically high noon. And you can look at it if you want to contact real estate agents or whatnot. There are certain times of the day that we were allowed to view the home when we were going to purchase it. So we did, and a lot of these things you can't see until dusk or something coming in. Hence, when I saw some of this, I was like, oh, okay, it didn't make that big of a difference to me, but let's see what's kind of moving forward. As you can tell, some of these pictures are pretty straightforward. If we keep going, you'll see photos of the living room, more pictures of the living room. You can see that deteriorated wall that is there. You'll see photos of the family room on page 11. You can see water seeping in. These are the waters coming in December during the rains. And when you look at that, this is clearly known. No matter when it rained, even when he lived there, it rained. And any amount of rain would come in and seep through. And not disclosing the information. And if you skip to the next page, page 12, you can see that water clearly is seeping in to the house. Definitely something that is known that was not disclosed, again, in this case. So getting back to it as well, you can see more pictures of the master bedroom on page 13, the extent of the water seeping in and seeping in continuously into this house, which, if he would have disclosed the information, understanding about the moldings that he hid, and the stuff that he left behind based on the Kills paint and different things of that nature, possibly cleaning the carpets and rugs and letting you know that there is leakage in the house, no willing and able person would have purchased this house for that price of the 1.1 as disclosed. You can see on slide 14 the cost to cure. So this is just cost to cure. I went in as an honest Abe. You'll even see in the mediation, it shows less than this because of the mediation dates and times that we had. More things pop up. No matter what, as everyone knows, you take something down, something else you find, right? That is a culprit of the same instance, and we'll review those. The comps you'll see as well, slide 14, and some of the closing remarks right here from this vantage point. I got to hit some more of these tabs so you can see it, but everything that is shown is a cost to cure. Everything that is quoted is just replacement costs, no upgrades. As I mentioned, hardwood floors are more expensive than tile floors. You'll see the quotes that I got in the back as well on that. Any knowledgeable, willing, and able buying person would not have paid $1.1 million for this property. Hence the reason why I base appeal. So given that fact, the assessment value, I don't know how you calculate based on land and things, which we'll go over in a few moments. I just took that dollar amount, subtracted it from the $1.1 million, which I paid, unbeknownst to me of these issues that were not disclosed, hence the lawsuit. The value should be at about, call it $720,000. I'll give you a few moments if you want. There's more pictures in tab 1 that go through this. in detail, zoomed-in pictures. You can see walls that were hidden, concrete issues. You can see trash that was left. We had to get a trash bin because if you know when you move into a house, it has to be cleanly swept, which it was not. And the individual left pretty much everything behind. You'll see that there were everything from toilets for the handicapped and dog beds to the nines. I can go into lots of details on that. The other thing was going back to roof, right? You'll see a picture of the second to last page, a rock on the roof. We didn't understand what that was until we contacted our neighbor. And you'll see that in tab 6, who my neighbor signed a note, sent it over, part of the lawsuit that stated, yes, what you're seeing is based on a tarp and things that were on that roof to hide and cover up the damages that were there. Now, going into tab 2, you can see that the description of everything that was paid cost to cure, attic, remediation of the rodent problem that was there, inspection, mold, remediation, project costs, electrical costs, floor replacement, remover of solar panels on the roof because of the bad roof that was there, and there's audio files and stuff along those lines that were made present to the assessor's office back in June that show the information as long as it was to the, I have the details as well on the lawsuit that I claimed and showcased to them that he definitely didn't want to fix anything. He didn't want to, he just wanted to get rid of the house, sell it, and get the heck out of Dodge from that vantage point. So I'm not going to go through every check that was made, every check that was cashed, every check that went there, but you can see everything in this section, section 2, were the payments that were made and everything that had to be done. So given the fact that the kitchen...
Are the actual checks also in the binders?
Pardon me?
Are the actual checks also
yes,
in the binders?
Yes, the picture of the checks are in the binders, correct. There are, if you look on tab 2, you'll see all the checks from all my different bank accounts as I was liquidating basically my entire funds to get this house back to a living state. Those are all them, because everything's digitized now. You never get the checks back in the mail. You just go online and they'll give you a scanned copy, if you will. Tab 3, we've already kind of walked through. You can read the text messages blown up of the assessor's office versus contacting me first to discuss some issues. You know, filing all the details and everything. They went to my real estate agent to verify. I don't know why someone would do something along these lines, not contact me first to get an assessment of the damages, but to verify, I don't know, maybe I'm lying or whatnot, but I wasn't. Which is great, right? It did verify from a real estate agent that we were telling the truth from that vantage point, my wife and I. Now, as Rick was going into from a comps vantage point, that's what tab 4 is, which I'd like to cover. So you'll see these are the comps that I put into play here, the low, the high, the average, the subjected property. The next couple pages showcase it in a little bit more detail, the binary, if you will, of it. But if you skip 2 more pages, you'll see the PowerPoint that I kind of put into place. So on this, you'll see everything is detailed out. The price I paid, the acreage, the bedrooms and bathrooms in the main house, original pictures, which Rick supplied as well from MLS. Because if you look at the details of this, it's all about the cost to cure, and I'm doing it based on the assessed value when I moved in. Me painting the house to a different color, changing the insides from white to yellow or pink or purple doesn't have any bearing on the base value of what I'm looking at right now. So this is the comparison we're looking at. So if you look at this home, you see the wood floors. You see a 90s style, if you will. As Rick alluded to, it was built in 1990. You can see all the appliances, everything pretty much from the 90s in here, right? So there's no remodels, no renovations, nothing and that kind of stuff was done. If you look at comparable number 1 that I have, 1268 Calle Pecos, about the same size. When you look at the details, a little bit smaller on square footage. It's similar to the comparable number 9, which was presented to myself. That one had a remodeled kitchen. I've outlined new floors, new paint throughout, gorgeous quartz countertops, new windows, none of which I had, right? So when you look at it, if you do based on square footage, yes, I had a little more, but in some cases, I did not have these upgrades or these amenities on there. But that's one of the comparables, number 2, as we're looking on that page. If you go to the next one, which is similar to comparable number 13, they presented to you guys as well. 4-bedroom, 3-bath, 1335 Calle Pecos as well, right? This is a lot larger. And if you look at these homes, at the end of this, you'll find on the last 5 pages, what I printed out was the HOAs on these properties. I've highlighted them. It's very small. I wish I could have made this bigger. The last 5 pages of that tab, it's literally microscopic. And I've highlighted with a blue color all the different properties. And the things I want to call out, as Rick called out as well, is the acreage, the lot size of all these houses in question. But the main thing is the code that they have for horses. It's a Lynn Ranch, right? It's all about a horse community, animals. And when you look at that and you do comparables, if we add a horse property, we can use the property to house animals, to board animals, to supplicant have a supplicant income coming in from that vantage point if possible. So, like I said, it's microscopic. We'll get to that in a moment. But you can look at the details as we go through this and we compare homes. So if you look at that listing comparable 3 to 13, you see the house there. Similar floors to what I had in some aspects. More upgraded appliances. Comparable 3, 1088 Calle Pecos. A little larger in the aspect of acreage, and typically anything about half an acre or more is zoned for horses. Anything below, depending, or you can have a permit, which we'll review as well. See the original listing pictures to that house. Very similar to what's looking at ours, except more upgrades if you see in the backyard as well. My comparable 5 and comparable 6 you see on that page 10, larger on the acreage size, larger on the square footage size, and a lot less on the price. Now, if you compare the comparables that they presented a moment ago, the next slide, these are the 13 properties, and we'll go into detail on those. There's my property as well. We can skip through a couple of these. And the reason why I put down 1/10 of an acre unusable, that's the front of the house, which is just a hillside that there is absolutely no use. You can't grade it, you can't live on it, you can't pretty much do anything to it. It's a huge slope, and you'll see it in that first picture on the left with all the trees. Blocking views, blocking all that kind of stuff if you want to look at that from a comparison. So if you scroll through those, which you've already reviewed, let's go to page 5. 1641 Calle Yucca, 1.2 million, 0.47 acres, zoned for horses. It's a half an acre lot with views, custom wrought iron gates. I've highlighted a couple things. Designer kitchen, you'll see these pictures. Entertainment resort style backyard, Pebble Tech pool, spa, rock waterfall. I mean, to the nines.
I'm sorry, can you clarify what page you're on?
Yeah, page, so it is slide number 5. So if you are on tab 4, you get to the PowerPoint presentation, which will show a number 1 in the bottom corner, bottom right corner.
So the numbered page 5 under tab 4?
So if we go to, let me count the pages for you really quick. 1, 2.
Oh, there's more than one.
So start on page.
There's more than one.
There's more than one 5, which is causing a little bit of
I apologize.
confusion. Maybe if you repeat the
Yeah.
street address till they find the right
Perfect.
number 5.
So the street address is 1641 Calle Yucca, and your comparable number 1. You'll see a picture of your comparable. It's in color, the 13. You see
It's
it?
the second, page 5.
And let us know when you find it so that you can
I
follow the
apologize. There's a
discussion.
lot of documentation.
It's about halfway through the whole tab. And there's only 2 page 5s, it looks like.
Yeah, I don't believe we used that comparable.
That was comparable number 1, I believe.
I think we did send it to you in the 1606 because we
Correct.
hadn't finalized our analysis.
Okay.
But if you look at the 4 comparables that we used, that is not one of them.
Okay, which comparables of the 13, at least on this chart? So unless you want me to review.
So you'll see we use 1330 Calle Pecos, 1068 Calle Yucca, 1943 Calle Salto, and 1872 Calle Salto.
Just to clarify for the board, We did a 1606 exchange on possible comps we would use, and then after we looked at them in the field, we naturally picked less comps, so.
So the comps.
So I guess that's, when, the confusion might be, he keeps referring to the assessor's comp, but we didn't actually possibly, from a field review, think it was relevant, so we didn't use it.
Okay, thanks.
So in the comps that you sent over during the 1606 then, Rick, really quick, it's comparable 8, 9, 10, and there was a fourth one I didn't catch. I think comparable 5, was it?
Well, if you look back to our presentation, our comparables are on page 4 and 5 of our presentation.
Okay, thank you so much. I'll just review those right now then. Much appreciated for the clarity. So we can, if you guys are on that page where it shows the comps 13, all the 13 that are listed, I'll just jump to 1872, which is the first page. Let me get to it.
I missed that one.
So if you turn to page 16.
I don't see any sections. No, 19. Oh, oops, I crossed the wrong one.
So on page 16, you okay? Okay, we'll move forward. So you can see that I marked that as a similar comparable to what we have there, given the acreage, except for the fact that it's zoned for horses from that vantage point, given the fact that, as I mentioned earlier, when it's zoned for horses, there's more options you have, the value goes up from that vantage point. So somewhat similar in the aspect, except for the fact that it's zoned for horses. There are other options in there as well that I didn't outline for the upgrades that they've done in that house. Then the next one that they had was comparable number 8. So if we skip forward to comparable number 8, it's on page 20. This is definitely a very good-looking house. Remember when it came on the market, it completely remodeled and gutted to the studs. And we looked at this house. This is also zoned for horses on a half an acre. You can see that it was completely gutted and remodeled. If you look at the details, it was remodeled to the studs. Contemporary, as it says right there, taken down to the studs, right? Looks over the entire canyon, has remarkable views of the aurora. Also sits towards the sunset as well. And if you look at the pictures down below, you can see that everything was done to the nines. Completely brand new, down to the studs, which isn't a comparison to when we bought our house and the way it looks at the beginning of these slides. Also showcasing the fact that we had the mold, they don't, because of the fact that it was completely gutted. The next comparable, number 9, 1330 Calle Pecos, about the same size, acreage-wise. The difference is this is remodeled chef's kitchen, new flooring, new paint throughout, gorgeous quartz counters, new windows, slides, a lot more than we had done to our house, but somewhat comparable from that vantage point. Skipping to 13, as I mentioned earlier, that is on over here, 1335 Calle Pecos. Much greater than ours, over a half an acre. And you can see based on some of the pictures, as I've talked about some of this, at the higher side of the price point of what they have here. Much larger, usable land. We sit on a hillside, as we have terraced. Not as much usable land as what they have, and a greater size.
So to clarify, we didn't use 1335 Calle Pecos in our analysis.
Oh, I apologize. I apologize. Thank you.
Oh, that's
You're
okay.
correct. You're correct. I circled because I thought you said earlier, and I just crossed it off. So
It was 1330 Calle Pecos, which I believe you used as well.
Yeah. So then the comparables in mind were the 5, 8, 9, and 10. So the streets were Calle Salto, 1872, Calle Salto, 1943, 1330 Calle Pecos, and 1068. My apologies. Now, in tab 5, this to me is the most important aspect of this claim, right, for the base year is what we're talking about. This is the documentation that we submitted into the lawsuit that we had against the previous owner. It walks through everything that we've gone through, all the individuals that I've stated, the tarp over the roof, knowing about the issues, knowing about the causes of the leaks, the details that was hidden. And at that time, the price that we came up with, based on what we knew to that date when we had to submit it, because of the case, when you do this, we had to submit everything that we know is there as a foundational starting point. And when we sit down in mediation, that's the numbers that we'd have to use. So this is what we knew going in of what the price point would be, not including and inclusive of the stuff that we did not include, just the Bell's policy portion of it, because that's when we started filing this lawsuit against them, and not inclusive of the other things that could be part and parcel of mold and stress and things that happened as well with the 3 miscarriages that we're going through in fertility. Going back to earlier, as I was asking, the reason why I asked about why is it recorded and, can things be held against me? Given the fact that I won the lawsuit against this individual, and you'll see the next page in front shows the NDA that I have signed, that I am not allowed to disclose numbers, dollars, and cents that were used in this lawsuit. I wish I could. I'd be more than happy to share it with you, because then you'd understand the dollars and cents that were won because of the fact of the issues that he did not disclose. Tab 6 we reviewed already in regards to the next door neighbor verifying the fact that he did hide things, right? I said I also submitted cases. I can play the audio files if you guys choose me to, but there's no way to print an audio file per se. So there's the audio files that I do have from the roofer, from the gardener, that did specify in recording, which they allowed me to do as well for that, to showcase that he didn't want to make fixes, he didn't want to make changes, didn't want to do anything. He just wanted to sell the place even though there was issues and he knew about. Hence the reason why I was talking about the Rule 2 that doesn't apply in this case. You'll see emails, the next tab, tab 7, emails going back and forth between everybody, showcasing the details of what I've shared. Feel free to read through some of these if you'd like. I'm not going to go through. You can see that there's been lots of communication going back and forth, continuously asking because they kept saying, I need the numbers. I can't. I have an NDA. And I was never given a response back of why. And I just kept, I need the numbers. I just can't share them based on that. Else, I definitely would. And if we go past some of the emails, you can see, based on the security footage and stuff along those lines, the video surveillance that I have, loaded by signs, contractors, and all that kind of stuff, that he did enter the property. And you can see in the previous threaded email and stuff like that, on the page prior, on June 16th, I told Brooke and Rick that I will be out of pocket the rest of today and then next week because of travel. I cover 4 states, just so you guys know. So I'm on the road quite frequently, covering the 4 states in the West. So it's all dependent on time and stuff that I can make available. I've asked for cell phone numbers, things that I can contact them after hours and things along those lines. Yes, please.
When Mr. Denham walked onto the property, was he walking in the areas that anybody who, like if somebody wanted to sell Girl Scout cookies and they walk up to your front door, that the publicly accessible front yard portion of the property?
The portions that I show you in the pictures were not publicly accessible. That's the backyard. Correct. It's gated. There's a gate leading into my backyard on both sides of the house. Correct.
May I address this?
Yes, go ahead.
Thank you. I do want to clarify, Mr. Denham did go out to the property and he did go inside of the house. The door was open. There were contractors there. It was cut short because he was asked to leave the property, which he did as soon as he was asked to leave. So we didn't get to see the whole property. We didn't get to see all of the work that was being done. And as soon as we were asked to leave, we did.
Okay, thank you.
And to add to that as well, they knew prior to going on site that I was not physically there. I noted in the email that I will not be home. Please don't come during this week. The Ricks still choose to come to the house knowing that I was traveling, right? And not physically there. And knowing what is done with the house to cost to cure, hence the MLS photos, right? It all goes back to what did the property look at based on the base year of what I'm filing against. I choose to change the color or something along those lines, let's see how it's deemed necessary. But like I said, again, came on the property knowing that I was not physically going to be there. He again stopped by on November 22nd as well. I was actually working from home and on business calls and video calls the entire time. My wife answered the door, said, my husband's working. I'm sorry, who are you, what's going on? Can we schedule another time? And we did. And he came by the house later on. I got the exact date, but I can look that one up as well. So I let him look around the outside of the property. Again, just trying to be constructive and tell people, I'm not here, I'm home, I'm not dropping by. It's kind of scary knowing that someone can walk around like that. And the fact that my contractor needs to know who's on property, because if someone gets injured, just walks through the front door, something along those lines, who are you, type of thing, he's liable for that. So, and you can see that he's in the backyard on the second, number 2 of that property. You can see that he's taking photos. He's in a work zone area. There's someone behind him cutting. Something could shoot off and hurt him and kill him. I mean, it's a dangerous environment to do that. After these photos, you can see the audit trail and all the details that I have been sharing. You can see dates, things have been posted. They asked me for as much as I have, and I have given everything that I can find, contact people. You can see mold reports. You can see there's the wave files back in June. They've asked them constantly. I'm like, everything is there. I don't know what to tell you. If you want access, you can. I have posted numerous times. There's an audit file after that, because with Box, the great thing about it is you can see when people downloaded certain files and what files they've accessed. And the audit shows on the 27th, which I believe was the day that we had our first session before it was pushed out to now, is the day that the majority of the stuff was downloaded. Some of it was downloaded prior to it as well. So to choose or not to choose, it's...
May I ask a question, Mr. Chair?
Yes.
Did Mr. Denham request to come to property when you were on site, and what was your response?
So, yes, and that's when we had him just come on site about last week.
But you said he came and looked at the outside. Did he ask to see the inside?
So when he said he came to the door, knocked on the door with another gentleman that was with him with a camera. And I said, hey, Rick, good to see you. And he came to the door. And I said, feel free to look on the outside of the property, no matter what. More than welcome. I'll walk you around, absolutely. And then he goes, I guess I can't see the inside. I don't consent to seeing the inside because of the fact that the property, based on a base year, is off of the MLS photos that are there, right? Not based on what the property is now, because I'm looking at a base year assessment of the mold and the issues and things that have happened. So having someone come into my personal and private house, to me, is not relevant to this case.
Do you have photos of after the corrections were made in the binder to the interior of the house?
I don't see a need to take pictures of the after of the house. Because the file I guess I'm going at is, the case that I have is, when I purchased the house, not a willing and able buyer would have bought the house if the information was disclosed. So the house was not worth the $1.1 million that I paid, hence the lawsuit, hence me winning the lawsuit, and him coming to the table and saying, yes, I didn't share the information with you. So that's where it landed. I don't want the dollars to slip out on accident. I don't want to get sued. So I'm trying to be cognizant of what I can share and what I can't share on an NDA.
Just give me your response. Is reviewing the interior of the house relevant to knowing if you were simply replacing or if you were upgrading? Is that relevant to that determination?
It's not, because the fact I provided everything that I purchased, the materials and the whole 9 yards and the cost. So you can look at the cost of that if you'd like to see exactly what it is. You see the stone that I purchased because of the fact that the mold, based on the mold report, if you want to read packet B of the mold reassessment, the walls and the exterior of the house, stucco need to be redone, the foundation need to be redone because of the mold and the remediation. So given that, the cost to cure, I did like for like or less. Hence the comment I made about the wood floors that are in there. I went to a lower material because I can't afford putting wood back in the house. That's typically about $15 a square foot. I went to, you'll see in the bill of sale over here, was $4.95 a square foot. So I undercut myself to live in that standard, if you will.
Thank you, Mr. Chair.
Okay, you're welcome. Are you finished with your presentation, or?
I can go on for days. I'm in sales.
Okay,
So
well.
I'll stop right there, and I'm sure there's more.
Can you just explain the second binder, the major
Yeah, absolutely.
categories of
Yeah.
information?
I'll do a high level of that. So the second binder, if you look at packet B, is the mold investigation report, the first one that was done. When we first located, you can see the date and timestamp from the individual that performed it. And you can look up them, and you can look up Chuck as well. He's got a PhD in this. He's unbelievably smart. You can go through the details of what type of mold it was, how toxic it was. I couldn't even highlight this. You can see some of the stuff on, if I go to a page. I didn't label the pages. You'll see some of the pictures yet black and white. You'll see his hand in some of these photos throughout this document. Observations about how mold would get in, where it came from, looking at the structure of where things were and the depth and issues based on laboratory samples of how bad the mold was. This is the first stent of it because he's like, we need to quarantine these rooms. And you saw the pictures of the beams, the rooms that were there. And then if you go to the second one, on September 9th, he came in and did more assessments as he started taking apart more of the house, right? And we couldn't live in this house at this standpoint in time, and had to live in the converted third-car garage that didn't have a kitchen, didn't have an oven. We had to eat out for a year. I'm telling you, I know every fast food place and every restaurant in Thousand Oaks. If you need a review, go on Yelp, put them there. And you can see, and also in tab 3, that's the mold investigation 2, and then the inspection report and a whole 9 yards, disclosures, transfer disclosures, et cetera, that you can verify that in the disclosures, and given the fact that if someone were to know this, even in an inspection report, if they were to know this, this house would not have sold for that price, given the issues that arose. And you can look at what he disclosed and what he didn't disclose, hence.
Where is the original disclosure of the seller?
My assumption is page 6 is the disclosure that I have from the seller information. Tab 6, the disclosure. Kitchen, ceramic tile, living and family room. That's all the information from them. Tab 6. Again, the fact that things were covered up, I wouldn't have bought this house at all, knowing this, or bought it for the value that I'm proclaiming based on the 1.1 minus the 380 to get cost to cure back. And if you want to go into more details about some of the mold that's here, I'd be more than happy to go through some of these things. Ventilation, because of the mold that was in the house, and I didn't even include some of that in the costs that were here. Ventilation need to be replaced, because if you guys know about mold, it clings to things and grows and festers. So again, as you see the numbers that were placed based on the settlement that I had, the 251, there is a delta 380 because of other issues that come up. I wish I had a magic wand or a crystal ball, I should say, to understand the details of this. I truly wish I did. If I did, we wouldn't be here probably today. I would have bid a lot lower. So I know there's a lot to take in. I appreciate the time and effort and energy. I'm sure there's questions. I'm sure there's concerns. Be more than happy to go through any one of these packets yet again. But again, the argument is based on the base year assessment, what I filed against, and any knowing, willing, and able buying party like myself wouldn't have entered this deal.
Okay, I think we have some questions for you.
Just a quick
Ms. Little?
question on the seller's property questionnaire. That's in your tab 6.
In my packet?
In your packet.
Packet A?
B,
Packet B. Packet B, yes, ma'am.
Tab 6. It's beyond the, there's the transfer disclosure statement, and then the agent's disclosure. Then there's on the left side, it says seller property questionnaire.
What page? I apologize.
Let's see.
Not a real estate person. I don't
Just
know where that is.
counting pages, not front and
Yes,
back.
please.
1, 2, 3, 4. On the left side,
Yes, ma'am.
dropping down towards the bottom,
Mhm.
under item 10. And I apologize for being insensitive, but I'm just curious. There's a handwritten statement there saying my wife passed away.
Correct.
In this house. Was it ever determined what she passed away from? Was it
Cancer.
anything to do with mold?
Cancer,
Oh,
when
cancer.
they don't know if it was determined based on mold, because his dog and his wife both passed away from that, and mold does have a case to cause cancer, so I don't know. Hence the reason we brought this up during the lawsuit.
Okay.
We brought this up, what happened, how did she get it, and he even had cancer as well. So all of this stuff freaked us the you-know-what out. Hence, we got out of Dodge as fast as we could, we quarantined the house, and went about doing what we could.
Okay, thank you.
Yeah. Hence the scare that we had with the miscarriages and that's.
Okay, back to packet A, tab 2, you have a cost. Under item line 3, you have project cost cumulative at $282,000. Is that including any of the, like item 1 or 2 or 4 through 8 in that 282, or is that separate?
Okay, I apologize. Which tab are you on? I apologize.
2, sorry.
Tab 2?
Tab 2, first page.
First page. And what was the question again, sir?
Line 3 says project cost cumulative at $282,000.
Correct.
Is that including item 1 and 2 and 4 through 8, or
No,
is that separate?
I separated them out for you guys so you understood. the
Okay,
difference.
so what makes up those costs specifically?
So if you look over here, you can see some of the costs that are there, that are outlined on the next page.
Okay.
And I've broken some of those out.
Okay.
You can see living room, and you can see remediations, you can see labor, kitchen, master room, family room, front wall, patio, and then from this, it would be,
So those are the 282
that's 218.
or 218, okay.
And then you'll see all the different checks from there, and if you total up the checks, given the checks based on the individuals,
Those add up to 282?
those add up to 282, correct?
Okay.
With all the other aspects in there as well.
And that doesn't include like the electrical and the floor
Correct.
replacement, any of the other items on this page?
No, the other ones, you can see that I included the bill, sale, and the other one. So if you start from the
Okay.
last page, right before tab
Okay.
3, you'll see those charges. You'll see the stone charges that I purchased. The contractor did not. I worked a better deal, I think, from that vantage point. The same thing with the stone. Because the mold in the house, if you look at some of the photos, there's a partition in the kitchen that separated the kitchen
Okay.
from the living room. And because the mold in the kitchen, that wall needed to be, if you will, demoldified. I don't know how to explain it,
Yeah.
right? So when you do that, the countertops have to be taken off, and the
Oh, yeah.
kitchen has to be removed and put in storage. It was brutal. I'm not going to lie.
And so where's the application? So you're requesting an enrolled value of 788,000?
Yeah, so what I'm doing is I'm just taking, and you guys can give me a little education, I'm just taking the 1.1 million was paid minus the cost to cure, getting down to the 719.
Okay, so that's minus the 380?
Yeah, because if there was if that was present at the time, anybody that moved in, cost to cure to get it back to the state that it was in would cost that amount of money.
Right. But then shouldn't it be around 720,000? You're
Probably, I probably 720 and change, but I didn't add
one
numbers.
page in here said 720, and then on your application it says 788.
Because the application started based on, when I submitted it, I
Okay.
don't know what until the
So
things
there was
progressed.
additional costs after you submitted it,
Correct.
they just keep piling up? Okay.
Yes, board, yep. You're correct.
Any other questions from the board? Assessor's office, any questions of the applicant?
Yeah, under tab 2, item number 2, you say inspection for mold and remediation certification.
Correct.
Do you have documents showing that they certified that the mold was gone?
Until I finish final payment, I will not get certifications. Kind of like when you pay for something till you make the final payment.
So it was my understanding that
Correct.
the remodel had been completed when Mr. Dunham was out there last week.
It's not completed there, that is incorrect. And it
What-
wasn't a remodel, it was a cost to cure, just want to make sure we get the right.
Well, that's a
definitions.
point we disagree on, so.
I know.
And the inspection for mold, we had only been provided from Mr. Colby
Correct.
a document showing that you had paid about $2,200 off the top of my head to Mr. Colby. Do you have any other documentation showing that you paid Mr. Colby for mold remediation?
He's not the one remediating the
Or
mold.
is it all to JR Construction?
JR Construction, correct. So he was the individual that provided the assessment, and if you look at his prices, they're quite high. So I went to a general contractor who was doing the entire house, and he's the one that's going to be taking care of everything soup to nuts. So he was the individual that my real estate agent told me about, hence, be careful. We hired him to do the first assessment, second assessment. He even told us, you know what, I'm very expensive. You can have your contractor do the same things and give you the same certificate and the whole 9 yards. I said, okay, I appreciate it. He's an honest guy, which is amazing. So, correct. I'm not getting it from him.
On the transfer disclosure statement, I noticed that the seller had mentioned that there was a soft spot in the floor. Did you do anything to try to determine prior to the purchase what that was and what that was caused by?
Unless we asked, and he said he did not know. Hence, the disclosures that he didn't tell us about was the leaks, the mold, and things that he covered up.
So
Hence the
beyond
lawsuit.
asking the seller if he knew what it was, you didn't try to figure out
We
what
couldn't
that
unless
issue
we
may have
ripped
been?
up, because we asked, we said, can we figure out what this is? The only way to figure it out is if you rip up all the floorboards, because that was in the hallway. And in order to rip up the hallway, the center floorboards, you have to start from one end of the house and move your way in, because if you look at it, they're tongue and groove and they snap together. So the only way to determine what that would be is if the seller would have agreed, and there's no way.
Okay, and did you, normally when you purchase a property, you would do a final walkthrough and
Correct.
inspection. Did you waive that?
Nope, we did a walkthrough.
You did a walkthrough, so you didn't see the trash and the debris, you didn't poke your head in the attic to see rat droppings. I mean, some of these things, in several of the pictures you had provided were ripples in the wall and
So we did the...
gaps in the wall.
Yeah,
And
so we did the walkthrough, and he wasn't moved out yet, because you typically do the walkthrough a couple days before. So we did the walkthrough a couple days prior to moving in. There's stuff laying around the house, which is fine, totally cool. Then we moved in, that's the way we got the property. Because everybody stated, even real estate agents and stuff said, it's okay, no problem, he'll sweep up, he'll clean up, you did your walkthrough, everything's fine. Just like when we sold our house, my wife spot cleaned everything, the whole 9 yards, we moved on. So we assumed he was going to get things clean. Assuming is a bad word, but you just hope that the person's going to be forthright and honest, and clearly he wasn't, given the fact that we had to go to mediation and resolve this.
Can you explain what all you did for the $282,000 of project costs?
Yeah, we did a cost to cure, basically. So all the mold, remediated and eradicated all the mold of the house and got the house back to where it needed to be. So given the reports that were in this finding, in the mold and what needed to be taken care of, we took care of it. So if you look at the living room, the family room, the kitchen, and the master, all had to be remediated for mold. And what that means is all sheetrock has to be removed. Depending on what the structure looks like, stucco had to be removed. If you look at the page, if you go back to tab 1, and you look at the first picture right there, the structure, that structure had to be replaced. If you go to 3, you can see that the headers had to be removed because of the mold. You can go to the 7th one in. You can see that the water damage and the warping of the boards had issues.
Did you get any other estimates before you went with JR Construction?
Yeah, we got multiple estimates, and JR Construction was the best price. I can give you the ones that are a lot more, and I did not want to go there because I couldn't afford the cost that they were going to do to cost to cure this.
Okay, so you didn't get any that were less?
None. And you can clearly see in some of these pictures here, if you want to keep reviewing them, you don't know what you don't know until you pull a board back and structure damage. Again, hence the reason why we went to the lawsuit against this individual.
Is there a reason you haven't included for the board here a copy of the plans for your remodel?
I have no plans from a remodel because it was a cost to cure to get things back to where it was. So I do not have plans.
You didn't pull a permit at all?
My contractor did, correct.
Okay.
He has permission to pull all permits. I signed over waivers for him to pull whatever permits are needed. Because the one thing I had to find out when I went to, because the great thing is there's one in Simi Valley as well that I can go to, and I said, I have a cost to cure. There's something wrong with my house. What do I do? Is there a checkbox that I can check because of the issues that I have? And they said, no, I think it's a remodel or it's a do a foundation or do whatever it is. And I said, how do I present this? Because I'm going through a case right now. It's not a remodel, it's a cost to cure. I'm replacing the things that were damaged so my house doesn't fall over and kill us. So if you look at the permits and the way they were pulled, I couldn't tell you. I'm not a contractor and how certain things were pulled in certain aspects. But that, given the case, all those things were done via, that's why you hire a general contractor.
Okay, so you never saw any plans? Is that what you're telling me? You never saw any plans that were
I saw
submitted
plans.
with the permits?
I saw plans, correct. I did see plans. And the plans were basically a flat format of what the house looks like. Correct.
Okay.
Prior, obviously you discovered this after you purchased it, is that correct? The mold?
Correct, and you can see based on the timeline and the dates, that is correct.
Perfect. How did you view the house prior to discovering the mold? What condition would you have described the house prior to discovering the mold issues?
I guess the question is, what do you think the house, I mean, based on the MLS pictures, right, and how the pictures stated the house.
No,
looks
I'm
like a
asking
house.
you personally.
Yeah.
How did you?
And the house looks like a normal house that a person would live in and create a family.
Average, good?
It's like an average house compared to some of the other comparisons that are out there. I wouldn't say it's great at all by any stretch of the means. I would say it's an outdated home from 1990 with some hardwood floors that are very nice that I couldn't replace because I couldn't afford it.
So when you submitted paperwork to the county, did you recall marking good on your paperwork to the county?
If you want to show me some documentations, I don't know. I couldn't. It was such
can't
a...
recall.
Mr. Denham, could you be more specific on
I
what
don't
you
know
meant
what
by
you're getting at.
paperwork?
Oh, I'm sorry, the PCOR.
What's the PCOR? Can you
It's
explain what that is, please?
every sadly, every escrow is supposed to give you a piece of paper notifying the assessor's office kind of what you're doing.
I
Do you
don't know
recall
what that is.
filling that out or signing it or marking good?
I don't.
Okay.
I can't. I wish I could answer that question. I don't know what that is or what that paper is.
And we also, you've stated, and I just want you to restate it, you've stated that you've received first of all, you stated that you have signed a non-disclosure agreement. Is that what you've signed? And is that what NDA is? I'm a little confused.
A non-disclosure agreement is what NDA stands for, correct?
Okay, so we don't really have a number of what your lawsuit was. We don't know if it's $1 or $1 million, correct?
Nope, that isn't correct.
Okay, that's not available for us.
It is, it's in tab 5.
There's actual dollar amounts?
Yes.
From the
Tab
NDA,
5.
from the NDA?
Not from the NDA, from the lawsuit that you just asked for. That is correct. We have the numbers from the lawsuit, correct?
That's from the lawsuit?
Correct.
So you're talking to the mediation agreement, the unsigned mediation, I'm sorry, not agreement, but the unsigned mediation claim that I do see there was a dollar amount tied to that.
That's the dollar amount that's tied to it, correct, based on where we were at
But we
that
have
state.
no evidence on what you may or may not have actually been awarded, is that correct?
So as I stated to you in the numerous emails that I couldn't get a response back, which I appreciated county council for clarifying that, is that the county council and the board cannot sign a mutual NDA with myself to share that dollar and cents, because I will be sued and so will you guys. If I share that information, I'm liable.
Thank you.
In order to share the information, I need the board and the county council
I
to sign
appreciate
off
you've
on a
explained it,
non-disclosure.
and you just re-verified it. That's
Yeah.
all I wanted. Thank you.
No problem, absolutely.
So the assessor doesn't have any further questions at this time. We do have some rebuttal documents that we would like to submit. If we could, I'd like to start with a document in relationship to the comparable sales that the applicant has provided.
Okay.
Can I ask one question about the question you just asked? If I'm having the exact numbers means, why having those exact numbers? What does that mean to the assessor's office? So if I was awarded $1 million, would that mean my property's worth $100,000? Can you define on why that number is so critically important to this assessment?
Can I please
don't know.
interject before?
Yeah. I'm just curious.
Tell me if my understanding is accurate, that you went into a mediation, a process of negotiation with the other side, with a mediator, a neutral, kind of guiding the
Correct.
parties to a settlement,
Mediation.
and that you successfully negotiated an outcome. Is that correct?
I successfully got an outcome that
And
I came to the
when you
table
say that I won the lawsuit, that you were able to receive an offer from the other side which you were willing to accept after going through the mediation process?
there was, based on this, $251,070.76.
And that was your opening desire expressed in the mediation brief to the other
I
side?
can't disclose information, as I said on the NDA. I can only tell you that $251,070.76. I wish I could. I apologize profusely if I could share information. I mean, I know you keep getting asked.
Right, but that $251,000, that's what you initially asked for, and you settled somewhere different that you can't tell us, correct?
I can't tell you.
You
You can't confirm if it was the same or different?
Okay.
Okay.
No, I understand.
I wish I could. If I do, because it's being recorded, I can get a lawsuit on me and I can lose my entire well-being. So I apologize. I can only go based on a number. I greatly apologize.
Okay.
So anyway, we're to take the mediation brief that you gave us as your opening request, and you can't confirm or deny that
The
what you
opening
received is
request-
the same or different?
The opening request is for the 380 because at the time, as I specified, because of mediation, there's a certain timeline that's stopping point. As you discover more things that happen because of the issue that I'm suing against, there's a compound on that. So the total is a 380, roughly, as you were mentioning, right, 720-ish, taking the 1.1 minus the 380.
All right. I'm sorry to interrupt, but I wanted
no
to
problem.
I wish
understand that before.
that was a good question.
You may want to re-ask your question.
Well, if I can just move on to this document that I just submitted, and if we could keep it Exhibit C, I know I marked it C, I will be submitting B, but I thought it might be easier to go through this one first. This one should be very quick. So just to point out a few things about the comparables that the applicant has provided today. I've actually gone through and I've highlighted in yellow the comparables and information about the comparables that I do not believe this board can consider. The first one is 1268 Calle Pecos. This was not actually listed in the MLS, and our records showed that it was an inter-family transfer, and therefore it was not considered a Rule 2 sale. The assessor didn't accept the sales price. We did enroll a higher value because, again, it was an inter-family transfer and not a Rule 2 sale. The second one, 1330 Calle Pecos, we actually used that one as well, and you'll see that in our analysis with the appropriate adjustments. 1335 Calle Pecos, it transferred almost a year prior. We didn't use that one because it was so far back in time, although I do want to note for the board that when I did put it into a grid and made the appropriate adjustments, it did support the 1.1 purchase price of the subject property. The next one, 1088 Calle Pecos, that the applicant used, this one sold beyond the 90 days, and this cannot be considered by the assessor or the board pursuant to Property Tax Rule 324D. 745 Camino Las Conchas, this one sold direct from seller, and it was not listed in the MLS. It was not considered an open market transaction, and it was torn completely down to the studs and remodeled after it transferred. I'm sorry, I won't say purchase. There was a transfer. And then the last one, 1040 Calle Yucca, it also transferred direct from seller. It had atypical financing that even if it had been a Rule 2 sale, we would have needed to make a cash equivalency adjustment for it. So because it wasn't listed in MLS and it wasn't considered Rule 2 sale, we wouldn't consider it as a comparable. This one also underwent a significant remodel after the purchase.
Can I make a comment?
Yes, go ahead.
So I guess on these, my argument has nothing to do with the sales comps or any of those types of things. With the subjected property, right? I want to make sure that we make adjustments to the properties that are there, given the facts of the issues that we uncovered based on the lawsuit and the fact that the disclosures were not there. So I don't see any other comparables with the ones I gave and others that have structural damage or things along those natures that came after purchase. So my argument is a subjective property I have minus the issues based on the lawsuit that we had.
I believe so. Any questions about Exhibit C? I think we're good. And this is Exhibit B?
It is. There's actually a second part to it, but
Okay.
It was kind of thick. I didn't staple it all together.
Okay.
But what you just got goes on top of what you're about to get. Thank you.
Oh, thank you, sir. There's a lot of documents.
So I'll start out, if I could go through the thinner of the two documents. I'll go through that quickly, and then we'll spend a little bit more time on the thicker packet you got. So on page 2 of that, kind of up at the top under the header where it says issues under appeal, I want to kind of just touch on these items here. I think what the board, just to kind of boil down the issues here, we're looking to ask the board to find, was this a Rule 2 sale? And if so, did the buyer and seller, did they disclose everything they were knowledgeable to disclose? I believe that they did. I believe the seller disclosed everything he was knowledgeable about. Things that may have been discovered after the fact are after the fact. This was, under number 1, this was a Rule 2 sale. It was listed on the open market. They were represented by professional realtors. On number 2, again, it appears the seller disclosed everything they were aware of. And if you look at the contract that the buyer signed, the applicant signed, it very clearly states that it is the buyer's responsibility to conduct investigations of the entire property in order to determine its present condition, and that the seller may not be aware of all defects affecting the property or other factors that the buyer considers important. Under number 3, while the applicant did provide us an unsigned document about what he hoped to get out of mediation, he has refused to provide any actual documentation as far as what those results were. Maybe there were things that the seller didn't disclose that he knew about? I don't think so. He won't provide us documentation to tell us
Can I make a...
what that may be. Let me finish my presentation. Thank you. Under number 4, I noted that a lot of the issues he brought up were things that were visible to the naked eye. Rippling in the walls, holes in the walls, the trash and debris that was left behind. These are all things that could have been addressed prior to the close of escrow. Dead landscaping was another. That seems like something, if you went to the final walkthrough and noticed that it was dead, you would probably say something. So the fact that he didn't, I assume was okay with it. I'm not quite clear on why he wouldn't have brought those very visible issues up prior to the close of escrow. The next one is we do have clear evidence that he intended to remodel the subject property as soon as he purchased it anyway. We have plans for a remodel. They're in this next packet. And then when the mold person came out to inspect, they had already started. They had already started their remodel. And I've put together a list of what I think the remodel entailed, the upgrades, not just a cost cure. This was very much an upgrade to the subject property. So when he's giving you these costs of close to $400,000, know that it was to upgrade the subject property to a much nicer state, and that there was a way that he could have remediated some of the issues if they existed in a much cheaper way that would be more of a repair replacement to what was there. So just to go through some of these things, he filled in a sunken living room. You'll see from the photos that we had provided in our initial presentation that the living room was actually a step-down living room, and there was a pony wall that surrounded that. So that sunken living room is now level with the rest of the home to make it more modern. He also took down the pony walls so it wasn't separated from the dining room and entryway. There's a bid, and we'll go through this. He received a bid to basically take out the existing kitchen cabinets and reinstall them, putting new countertops up, but just taking the existing cabinets, they were in good condition, and putting them back. He chose not to do that, but that was an option to remediate. What he actually chose to do was to completely remodel the kitchen. He completely moved the fixtures around. He tore a wall down to make it a more modern, open floor plan. He did a lot of upgrading in the kitchen area. He upgraded the front door. I don't know why he would have needed to replace it if there was mold, but you will see from the photos that it was absolutely upgraded and not just a replacement. There were new appliances, cabinets, and countertops. He reconfigured the master bathroom. He decided to relocate the furnace to the attic so he could create a closet in the hallway.
That's incorrect.
He put new flooring throughout the home. He refaced one of the fireplaces. He removed a large interior planter. There was electrical work done. There was, I don't know if he removed the AstroTurf or not. I suspect that when he went out and he says it was dead, yes, it was dead because it was AstroTurf. New landscaping, new pavers surrounding the home, front and back. Very nice pavers. AC replacement, roof replacement. And I will note that I did listen to the recordings provided by the applicant that he had with his roofer. And he told the roofer that he wanted a Mediterranean-style roof, so because he didn't like the color of the old roof. So he chose to replace the roof when, in fact, he probably could have just repaired whatever issues there may have been and used the same tiles. They were very nice tiles that could have been reused. He chose not to because he didn't like the color. He replaced the stove gas line and the vent. He put new windows throughout the home. He repaired the wall on the exterior staircase leading to the house. Again, something that would have been visible to the naked eye if you, looked at the wall when you were purchasing the property. And he painted the exterior of the house. I'm not sure if he stuccoed it or not. So this list, I compiled it based on the permits, the plans, and an incomplete interior inspection that Mr. Denham did do, and he couldn't complete it again because he was asked to leave by the contractor. And Mr. Denham went out there last Thursday, I believe it was. As Mr. Kalau stated, he didn't allow him to go view the final product, basically, and denied us entry. Presumably because he didn't want us to know that it was in fact highly upgraded compared to when it was listed. So let me turn your attention to the other packet. On page 1, you will see the permit that was pulled to remodel the living area, remodel the kitchen, the bathroom, replace skylights, change out the air conditioning condenser, a duct vent, replace the stove appliance vent, replace 5 fixtures. There was a significant amount of things done to the property. On page 3, and page 4. These are the plans that were submitted with the permit that was pulled. And these are very interesting. You'll note on page 3, that's how the property existed at the time of transfer. Page 4 is showing you all the changes that the applicant did to upgrade the property. You'll notice in the living room that he removed the half walls to create an open floor plan. He also filled in the sunken living room. You'll notice that there was a large planter area in between the family room and the entry area. That planter area was removed, presumably to make a more open and modern floor plan. And same with the kitchen. There was a wall. It previously had been kind of more of a galley kitchen, and he opened that up. He moved the fixtures around. You'll see that the sink was in the corner. He decided to move it to the island. There was a stove in the island. He decided to move it to the wall. He completely reconfigured everything, and that's all very costly items to repair or to move and to upgrade. To move gas lines and water lines and sewer lines is all very costly, and all things that he's trying to wrap up into his what he calls a cost to cure. I call it an upgrade. I call it very much an upgrade. You'll also see if you know, if you take a look, you'll see that the old master bathroom looks a lot different than it did. He moved a sink from one wall to the other, so the sinks were side by side instead of being across the room. He put a freestanding tub. He changed the layout of the shower. I mean, the list goes on and on and on of all of the things that he upgraded in his home. The forced air unit, I believe, went to the attic. You'll see that it created a nice larger closet. He built a new wall to actually not just take the forced air unit and make that area into a closet, but to make a bigger closet than the forced air unit would have provided. You'll see that there was, on the next page, page 5, there was some electrical work done. I did ask Mr. Kalau, I tried to get information from him on the electrical work done. He provided a check, but no contract. I don't know specifically what all was done. He refused to speak to me. On page 7, this is perhaps one of the most interesting documents that is in this presentation, aside from the plans that we just went through. But on page 7, this is another bid that Mr. Kalau got. And you'll notice that I highlighted the portion where, so they were basically going to repair and replace a significant amount of drywall. And this particular document, you'll see that they actually bid to reinstall the kitchen cabinets, because remember from the pictures, it was a very nice kitchen with very nice cabinets. And so there was a possibility to reuse that. He chose not to do that. He wanted to upgrade it. He was already intending to remodel the house from day one. On page 9, you will see that they even talked to the mold inspector about the fact that they were remodeling their home. Down at the bottom of the page, our client tells us that the shower is being demolished in connection with their remodeling plans. So again, all of these costs that Mr. Kalau was trying to claim as a cost to cure was actually a planned remodel from the get-go. So the other documents, I think from page 13 and 14, I think the applicant did provide that document to you. Page 15 is another document that, you know, is for items that, again, would have been visible to the naked eye had you poked your head up in the attic prior to purchase. And then starting on page 17, these are the photos that Mr. Denham was able to take when he did go out and come and do his partial inspection until he was asked to leave. You'll see on page 17, this is, I think, from the street looking up. You can see just a hint of the new door that was installed. You'll see that the roof is a different color because he wanted that Mediterranean look. Page 18 is the front door. And if you would, on Assessor's Exhibit A, if you could open that up to page 13, I'd like you to compare the before and the after. Page 13 of Assessor's Exhibit A. So it's a white door. There's a window above it, a half-circle window above it. Fairly plain. It is a double door. And page 19 of Assessor's Exhibit B also has a nice picture of the newly upgraded front door that you can compare to the old one. And I think it's pretty clear from the photos that this is not just mold remediation or anything like that. This is an upgrade to the subject property. Page 20 is an incomplete photo, but you can see that they completely are reflooring the property. I think the area to the right in the photo is where the planter area was removed. Again, not something that I think needed to be done in order to remediate mold, something they chose to do because they wanted to upgrade the home. Page 21 and 22. 22 is the new kitchen with all of the new appliances that have been moved around, new cabinets, new lighting. And if you compare that to page 18 of Assessor's Exhibit A, you will see very clearly that this was an upgrade, not a repair replace. Remember, we have a bid where they would have just reused the existing cabinets, they would have replaced them, put them back in place. Instead, they chose to upgrade the subject property. Page 23 of Assessor's Exhibit B shows another glimpse of the kitchen prior to its completion, which again, we were not allowed to see. Page 24, a photo of the new windows that appears as though the windows throughout had been replaced. Page 26 is, I believe that's the living room. You can see now, if you compare it to the old photos of the listing, you can see that it is no longer sunken, there's no longer a half wall, and the fireplace has been refaced. Page 28 shows the new and upgraded pavers that were installed. I believe that's the backyard. That extends to the front of the house as well. So again, those pavers that were installed all around surrounding the property are included in the almost $400,000 that the applicant is hoping you will take off of his purchase price. Starting on page 30 is the state of the property as of last Thursday, at least the exterior of it. You will see that they did do some repairs to the wall. They added some fencing alongside the stairs. And then page 32, the rear entrance. Page 34, you will see it's the guest house door. I'll also note that it appeared all of the exterior doors had been replaced. I'm not sure how that might have to do with mold remediation. I don't think that that would have been necessary, certainly not an upgrade to that level. These were very nice doors, just like the front door. And if I could go ahead and hand out one more document here. So this document I'm handing out now is an excerpt from Assessor's Handbook 410. I think we're on D now, yes.
D, yeah, Exhibit D.
So this is an excerpt from one of the assessor's handbooks on a newly constructed property. And I want to make sure we get our terminology right. The applicant wants to call everything a cost to cure. That's not accurate. If you turn to page, it's labeled page 6. It's actually out of the handbook as page 6. So if you turn to page 6, it goes over in detail what the terminology means as far as property tax valuation is concerned. We have replacement, which is substituting an item that is fundamentally the same utility. It's normal maintenance. It doesn't make it substantially equivalent to new. There's remodeling, changing the plan, form, or style of a structure. Certainly from the photos before and after, we are changing the plan, form, and style of the structure. We've made it an open, modern layout. We've filled in sunken living rooms. We've put in a new, beautiful wrought iron front door when the one there was, in fact, had utility and worked just fine. Rehabilitation, modernization. I just wanted to provide this so when you're deliberating, you can look to the terminology of the State Board of Equalization and make sure we're all on the same page as far as the terminology that we should be using.
Go ahead.
If I may ask a question. In one of the materials that the applicant presented today, and I couldn't tell you where in the two binders it is, there was a reference to the seller for the 3 years prior to the sale putting tarps on the roof anytime it rained. And that, to my mind, is pretty unusual. People normally don't put out tarps every time it rains. Is there anything in the seller disclosure that, to your mind, puts the applicant on notice that basically there's a temporary tarp required to be used every time it rained?
So, two things. That is unusual. I agree. It's unusual to put a tarp on your roof for any reason. So the trigger that I think there were visible signs in the home of the walls were wavy. I forget the term that was used, but there were actual visible signs on the walls that would have been visible to the naked eye that if you were purchasing a home and you saw that, I think that would give me pause. And I think, here's the thing, I think he did. He intended to remodel it from the get-go. I think he knew about these issues. I think he knew about at least the visible issues that were there. There was a soft spot in the floor. That would concern me as a buyer, to know that there was a soft spot in the floor. To just ask the seller, well, what is it? I don't know. I think I would have hired somebody to look into it a little bit further. I don't know if I've answered your question, but I think he knew about these issues. I think he knew about the visible issues that were there. To just ask the seller, well, what is it? I don't know. I think I would have hired somebody to look into it a little bit further. You know, I don't know if I've answered your question, but I think he knew about these issues. I think he knew about the visible issues that were there. To just ask the seller, well, what is it? I don't know. I think I would have hired somebody to look into it a little bit further. the whole roof didn't need to be replaced. Even if there were issues, it didn't need to be replaced. It was in his recording that he wanted a new color. He wanted the different color roof. He didn't like the gray roof that it had. He wanted a modern Mediterranean-style color. So I think there's a lot of things that he chose to upgrade. Maybe there were issues and that needed to be fixed, but he chose not to just fix them, but to substantially upgrade the property. So that's kind of where we're at.
Thank you.
Okay, you had a few comments a while ago?
Yes, sir. So everything that's being stated right now is subjectional, right? The subjectional matter for what's going on. And my curiosity is, where did the assessor adjust for the mold, the roof that had to be replaced that I stated? No matter color or not, that doesn't matter, it had to be replaced. Structural damage. I don't see anything in these as factual, detailed data that says where the assessor did it. They're looking at...
Okay, are you starting to begin your closing comments?
No, I'm leading to the question of where the assessor adjusts based on what their comments are and these pictures that they're showing. Adjust for mold, roof, structural damage on this. They're saying that I upgraded versus I didn't. As I mentioned earlier, right, the floors had to be replaced. As documented proof that I have based on the lawsuit and others, that if flooring had to be replaced, if I went with the flooring that was there like for like, I would have spent a lot more money. Second, if you look at the kitchen to replace, the cost that I'm only going for are the cost to cure. I did not go for any, if I wanted to buy a new door, I bought a new door, which is not included in this. The things that I chose to purchase on my own are not included in any of this documentation. That's up for me if I feel like changing a color of a window, or I feel like changing the color of the paint. That is not the basis of my claim. The basis of my claim is the fact that at time of purchase, and I did a base year assessment, not where we're at today as they're claiming. So my curiosity back to them is, from that, I'd like to see where they did adjustments for the mold, adjustments for the roof, adjustments for structural damage, that I have facts and evidence on this, and subjectual natures of changing forced air units, that wasn't moved. That was where it was. The things that they're thinking, they're subjectual. And the other thing is, I filed this, I didn't file a C2 for contesting the structure or the reconstruction. I filed a base year. So as they're talking about this, I filed a base year. They're talking about something that is not in existence. I believe, I'm trying to look at the handbook as well, section 502, I think it's 21, physical deterioration. We can look through that as well as what I'm getting at here, is a deterioration of this property, of this house. And that's what basically happened to me, and this is basically a mischaracterization of what's going on in this property. I have facts, and I'm looking for facts back. So I guess the question, the long-winded answer is, if I can see some facts that they have for where they're taking into account the mold, the roof, the structural damage, et cetera. Whether it's a different color, it doesn't matter based on the purchase date of August 19th, 2016.
Okay, was that it?
It wasn't my closing statement. But
oh, no, I know.
Oh, yeah.
Yeah, we're not there yet. Okay.
Yeah. And if I need to get that portion I was talking about of the physical deterioration, you're more than welcome to read it out loud. I think it's 502, page 21 of the handbook.
Okay. Okay. Do you guys have any additional comments, questions?
I do have a question. You just made a statement, which is new, that now the project costs don't include everything. Have you provided a breakdown as far as what is included or what's not included in those project costs?
Everything included in the project costs are cost to cure, things pertaining to the mold.
So how do I know that? Where is my documentation to show me that?
So JR Construction is the person that did all the details based on what's outlined. So everything that's outlined in the documentation with those checks
Right, so they
that.
replaced all the doors and the windows in the kitchen and all of that.
And that's not in what I'm arguing.
So where is that estimate?
That estimate's not, because I'm not arguing those estimates of what I chose to change. The estimates are cost to cure of the issues that I had with the mold. I'm not going after any of that stuff. Hence the lawsuit that I had and that I claimed.
So are you
against this
telling me you
individual.
have another estimate from someone that you did not provide me,
No.
even though I requested it?
No, I gave you everything that I had. That is correct.
You just
All
told
the-
me you had another estimate
No
that
est-
included the other items like the doors.
I went out and
the-
purchased a door. If you want to see a bill of my purchase of the door, I will give you the purchase of that door. If you want to see my purchase that is aside from this construction
So, and then
company,
JR Construction installed it.
and JR Construction in this aspects, certain things that were part of the right to remediate. So for instance, in the picture that you showed, I'll review it as well, because this is what I want you to get an understanding of where this is. So if we go back to your documentation on page 17,
What
Exhibit
exhibit are you
B.
looking at?
Exhibit B. There's other pictures that you did not take or did not show, and this is the date that, as recalled, I told you that I was not going to be on site as Rick decided to go against my will and my construction crew's will to come on site, given the facts of these dates, right? So all of that, as you see, is based on mold. And you can see in my pictures, based on the remediation that I had to do, things had to get replaced. The stucco, the foundation, the fixtures, all that stuff. I don't know what else to tell you guys. I mean, I'm trying to figure this out as we're going through this process of everything that is here. I presented the case that I have evidence of the issues and problems that happen within my house. I would not, if this was in documentation, I would not have purchased this property, given the fact of these issues, if they were disclosed. Yep, go ahead.
I'm looking at your tab 2 in packet A,
Yes?
and it's from Colby, and he has October 3rd talked about what had to be done for the mold and to cure all the mold, and it came up to 54,000 plus maybe another 6, 7, 8, 20.
This is in tab 2, correct?
Yeah, it's the,
Yep.
from Mr. Colby.
Mhm.
He's saying it would cost approximately maybe 75,000, so.
That's just
that's
for,
all the mold to be remediated.
that is for, let me get it really quick. You said tab 2? Trying to find out which tab it's in.
Yeah, your tab 2, and it's from SOS Mold. He says the scope of work is for the main living room, kitchen, family room, master, remove and store contents, contain work areas, tape off HVAC registers, cover and protect floors, remove built-ins, remove sheetrock, sand and clean, disinfect all framing members.
Where I'm not seeing, it. Are we talking
Just a one-
exhibit?
it's just a
packet B?
one-page.
Packet B or packet A? ma'am?
Packet A.
Oh, I apologize. Sorry, I'm looking at the wrong one, because that's where the mold stuff was.
Packet number 2, and he kind of has everything that has to do with mold.
From what he can see, so if you look at the pictures of the squares that have numbers on them, on the mold, until things are removed, you cannot figure out what to remediate. So based on his given assessment, I'm still trying to find the tab 2. I don't know why it's not here.
Yeah, it's like halfway, yeah, almost more closer to the back.
So tab 2, where the first shows, the first page shows 380,000, that tab?
Let's see, the first page. Yeah, but if you go, it's maybe 5 pages from the back.
Oh, from the back, I apologize, ma'am.
I'm just looking, because his estimate was a lot lower, and then, it didn't say anything about doors. It just said, I think it said to replace the kitchen cabinets.
Correct. So if you look at the diagrams and the diagrams that are shown, the kitchen, the walls needed to be removed and replaced. As stated, the
Yeah,
kitchen
he
needs
has
to be
that in
taken
there.
out and put back. Certain things have to get repurchased, like for like.
Well, it says remove sheetrock and insulation from all interior surfaces, sand and clean. It's just his estimate seems a lot lower when I'm just looking at this.
So his total cost right now is 54 plus other
Yeah.
costs on top, so 60-something. If you look at my contractor to do that, was a lot less, 36. So a lot lower than the 54. And the other one that they presented was 48, my costs were 36.
All right, now, okay, So this would have just remediated all the mold.
This would remediate mold, not including, bring it back to where it is. Remediation of mold, correct. Well, if you look at my contractor and where he came in, a lot lower on that estimate.
Chairman, can
And
I
one thing,
please-
as I mentioned earlier, right, as we were talking through this, is to emphasize the Section 502, physical deterioration. Physical deterioration is a loss in value due to the cause of the forces of nature. Physical deterioration occurs to virtually all improvements as they age, and I can keep going through this. They be classified as curable or incurable. So again, the facts that I presented, and I can go on, I mean, it's a long list, and you guys can review that when we go back, is the fact that if this was disclosed, then things would have been different. So it's all based on the base year I'm looking at.
If you did not find any mold on the property, say you moved in no mold, you would have had remodeled anyway?
The house would have been fine to live in. We didn't have plans at the time until we talked to these individuals to say, okay, this has to be replaced. Okay, let's replace it. And like I said, if there was a checkbox that I can do, cost to cure that you guys have for filing things, there's no, and I asked when I was there, I'm like, I need to get this back to square one. The only thing you could check is it's remodel. You have to pull permits. You pull walls down in structural and foundation. If you look at one of the pictures that I shared in tab 1, the first picture right there, that entire wall structurally had to be moved. It had to be braced up. Headers needed to be replaced. As you see the picture next to it, those beams and things need to be replaced. I can't determine the cost when it just says to remediate certain aspects. You look at page 2, page 3. Page 3, that's another structural supporting wall on the side. I can't I'm not a licensed contractor to determine what needs to be replaced and fixed. I apologize if I painted. I apologize if I changed the color because the house was torn up. I do. If you wanted me to keep it the same color and, I don't know what else to say.
May I ask a question?
Yes, go ahead.
One of the pictures that the assessor showed in the later exhibits was all those beautiful pavers in the backyard. Are they included in the 282?
No, ma'am.
Okay. And
That was a different company that worked on this.
Okay.
Augustine.
So can we look at all the checks, and if we were to just physically add them all together, would they come up to the 282?
When I added them all up, I believe, we can do the math really quick if you guys would like to run through it. We can look at all this stuff and figure out what those costs were. When I put this together, I put in a spreadsheet, sum, and got the total. If I'm off by a penny or two, I greatly apologize, as I put them in the documentation.
So is all the support for the number that totals 380,488 and a penny, is all the support for that in tab 2, or is it somewhere else as well?
All the checks and everything support that in tab 2, correct. And so my question, I guess the question back is, were these adjustments made in their assessment? The issues based on the lawsuits that I had that were factual, of the molds, the roof, the structural, et cetera.
Okay. Any other questions? Still kind of working on it? Okay. Any other questions of the applicant?
Was there a question there for us?
The question that I asked a couple times wasn't answered was, where did you guys adjust for the mold, the lawsuit, the issues? in your assessment based on the base year?
So we didn't.
Okay.
We did not make an adjustment because we didn't feel one was warranted. We feel that everything that was knowledgeable to the parties was disclosed, and that you bought this house fully intending to remodel it. You told Mr. Denham when you started working with him that you found the you found the mold because you had started your remodel. You told the mold person, and it's in his paperwork, that you were planning to remodel the bathroom. Clearly, there was plans that you had drawn to remodel not only the master bathroom, but the rest of the house to make it more modern. And I also noted in our analysis, you'll see that we note that had you actually only remediated mold, even if we made an adjustment, even if we agreed and made a $50,000 adjustment based on the bid that you had provided well before this appeal, you had contacted our office and provided the $49,500 bid to just reinstall the existing cabinets and repair the drywall, it still would have fallen within the range. It still would have fallen within the range of value established by the comps. Your $1.1 million still would have been accepted even if we agreed and made that adjustment based on an actual cost to cure, not including the upgrade costs.
So one thing, before the final closing, I just want to remind the board and the council that the assessor's office has the burden of proof, right? And they have not made any adjustments. And they said on record that they did not make any adjustments, as you just stated, with all the information that was provided. The burden of truth, the fulfillment for the burden of truth, and I've just given ample amount of information and documentation to show this. So I just want to make that as a note before closing.
Okay, thank you.
I haven't seen that proof yet.
Okay, if you'd like to make your closing statements.
Yes, sir. I want to note that I was not fully aware of the issues at the house. And if I would have known based on the disclosures and the lawsuit that we did, we would have not have purchased the house at this price point. I want to also conclude that any willing and knowing buyer would have not paid this price for the house in the condition that it was in, but not told and, of course, lied to, hence the lawsuit that we had. The point of the marketplace is that there are different price points, as you can see. But all of this was not taken into account because of the disclosure not being disclosed. If you look at what the others paid, given the sample comps, you will see that given the condition of this house to do a cost to cure, you will see that these totals over the market value, $380,000 that I'm going to. If the bank would have known about these issues, the realtor and other parties about this house, it would have not have been sold at this price. The previous owner did not disclose this, and it was deemed, based on the lawsuit, that the issues, as documented as proof, were there, and it was not disclosed. Hence, we won the lawsuit against the claim. I was not fully informed. I was not aware of these issues. And if you look at the details of this property, it was not sold as is. So, at reference to Section 502, physical deterioration, I'll read this little section. Physical deterioration is a loss in value due to the use or the force of nature. Physical deterioration occurs to virtually all improvements as they age, lowering their utility and consequently reducing their value. Examples of the physical deterioration are peeling paint, metal fatigue, flood damage, termite infestation. Proper maintenance can slow a building's rate of physical deterioration. Physical deterioration may be classified as curable or incurable. Curable physical deterioration, also called deferred maintenance, occurs when the value added by a repair equals or exceeds the cost of the cure of the defect. Incurable physical deterioration occurs when the value added by the repair is less than the cost to cure the defect as of the value date. That is, it is not economically feasible to repair the item. When estimating physical damage, the physical components of an improvement are divided into two types, short-lived components and long-lived components. Short-lived components of an improved, example, roof, covering, elevations, or mechanical systems, that compounds that. Please take into consideration the home as the state it was in before the work that was done, as the issues are still the issues. And just because we are making our home in the style that we choose doesn't mean these problems did not exist when we purchased this property. I'll leave you this. Any knowledgeable, willing, and able buying party like myself would not pay this amount to purchase this property if this were disclosed. Hence the cost outlines as facts of the cost to cure at the base of your appeal. And again, I remind the fact that the assessor's office has the burden of proof here. They have not made any adjustments and set on record that they did not make any adjustments. Thank you so much for your time. Appreciate it.
Thank you. Okay, assessor's office, closing comments.
Well, I think I'll go first, and then I'm sure Mr. Denham will have a few things to add. But I do want to clarify, and as I stated in the beginning, we do accept the burden of proving that this was a Rule 2 sale. In fact, it was. It was listed in the MLS, it was listed on the open market, and it sold between a buyer and seller that were knowledgeable to everything they could be knowledgeable about and disclosed those things. After that, the burden does shift to the applicant to overcome his purchase price of $1.1 million. What's interesting about this case is there's a lot of documents sitting on each and every one of our desks right now, but there's no actual evidence in front of any of us that shows what was a cost to cure for mold and what wasn't. The applicant has said under oath today that he did not comply with the assessor's 441D request. The applicant did not provide documents that the assessor requested in the form of bids and other documentation. He said he got lots of other bids, but he refused to provide them because he didn't think it was relevant. In fact, it's not up to the applicant to determine the relevancy of the documents. It's up to the applicant to comply with the 441D request so the assessor can do their own independent analysis of the documentation and the facts. By not providing those documents to us, he is not allowing the assessor or the board to actually do an independent analysis. He's simply refused to provide relevant data about a problem that may or may not have been known at the time of sale. It's also very interesting that while he told Mr. Denham in the beginning that he was planning a remodel, and he told the mold person that he was planning a remodel, he's now deciding that maybe he wasn't. I'm not sure why the story keeps changing. But it's very interesting that up until today, he was claiming that the $380,000 included all of the project costs, and now he's saying it doesn't. But he hasn't given us a breakdown as far as what it does include. He's given us checks that I'm confident that he's paid a lot of money for this upgrade. But by not giving us and not disclosing to us a detailed account of what he's actually paid and to whom, he's prohibiting the board and the assessor from looking at the facts. It's not up to the applicant to decide what's a cost to cure and what's not. It's up to him to provide us the data so the assessor can make a recommendation based on the actual information that has not been made available to us. He also denied us entry into the property to do a full inspection of the subject property. Admittedly, Mr. Denham did go see a portion of the property when it was in an incomplete state. And what we saw when we went out there was a property that was being significantly upgraded. not being able to go in after the fact, I have no idea what the final product looks like. Well, I have a little bit of an idea, and as you can see from the photos, I think the front door speaks for itself. That was a highly upgraded item that, you know, if you were replacing like quality, you would not have chosen that door. Other than that, I just one final comment before I pass it over to Mr. Denham. There was actually a lot more data that I have learned about today that was not disclosed to the assessor, despite repeated requests for it. So I would encourage the board in their deliberations to turn to Section 501, which discusses the failure to furnish information. And it says that if after a written request any person fails to comply, it says the assessor, based on information in his possession, shall estimate the value of the property, and based on this estimate, promptly assess the property. Because we weren't given the luxury of knowing what is included or what's not included in that $380,000, we really can't make an educated determination if a deduction should be made or not. I would also ask that the board review the case Sims v. Pope from 1990. And that one, the quote of note is that if the evidence is less than the best, the taxpayer has no one to blame but himself. So it's really, the burden is on the taxpayer to show us the documentation as far as the breakdown of, you know, was the door included, was it not? He said today that it wasn't, but how do we know that? He hasn't actually provided us anything to substantiate that. And with that, I'll pass it over to Mr. Denham to conclude. Thank you.
Thank you. Thank you, Rick Denham. Something to note, one of the hard parts about a case like this is we've actually had a prior case similar to this, but it was settled prior to reaching your ears and your judgment because of the documentation that they had. And so we know what documentation to look for in different aspects and how the case should look. This case did not look like the prior case, which should have been similar. Documents were missing from day one. They had a judgment just like this. They gave us the number from that judgment. Then they gave us the detail of that judgment number, meaning some of it was for the problem and some of it was for lawyer fees and other things, so that we could come up with a reasonable number based on that particular case. This particular case is a little unique in the sense that now, according to the applicant, there is a number out there. And I literally said it's between $1 and $1 million just to kind of put it in some range. But I don't have that number, first of all. And secondly, I don't have a way with documentation to judge that number. How much was mold, how much was attorney's fees, how much was, related to a problem. The other thing about, is all of this cost to cure or is it a remodel? Sadly, we do disagree on that point, and this very intelligent applicant was very aware that we disagree on that point. I do not underestimate his brain power at all. And so he was quite aware and quite concerned that I would see the inside of the property. And unfortunately, past history tells me there's only one reason they would be concerned. And when I looked at the plans, and literally from the front door on, it indicates that there was remodeling going on. There was strong indications when I first spoke with him. He said they discovered the first piece of mold when they were starting to do remodel. They didn't just find it, fall through the floor. Once somebody removed a board because they were going to, specifically, they were going to build up the floor of the living room, which I thought was a great idea. I hate step down in living rooms, so. But clearly that told me they took an intelligent look at this property and that they plan to do some sort of remodeling from day one. He's not arguing that the house wasn't in good shape, and I have no doubt they probably made it better, because if the door is any indication, that's really good taste. The other thing that I would point out that's unique in this case is that we have two different situations going on. We have the Rule 2 sale. Was that fair and square? After that, there was a discovery, and I'm going to give them, that there was a problem. I'm going to say there was a problem, okay? But that problem that occurred after the Rule 2 sale was, in fact, by this non-disclosure agreement, cured, okay? It was cured. So now we're back to the sale. The sale was fair at the time. Should he have looked a little more? Was the guy sneaky? I don't know any of that, neither do we. But I mean, he's pointed out a few things that he observed from the and maybe didn't follow up on. And whatever happened afterwards in the way of damage was cured, apparently, through some sort of litigation. And it's like any home that we may look at. It might sell here, have something else occur here, and move on. But it doesn't change the date of sale. Was it fair? Was it Rule 2? Did he have other choices? Was he well represented? And all of that criteria is met. And that's why we are supporting our position to uphold the sales price at that date, and to recognize, if you have any concern about anything that happened to him, it was cured. He was made whole at some point in time about a problem discovered after purchase. At least full, and that's even questionable because apparently there were some hints, but let's just say verified after purchase. All right? And that's our position. That's why we are here today, and that's why we presented the case that we did, and that's why we showed you the plans and all that other things. Thank you.
All right, thank you very much. We will deliberate this one behind closed doors, and we'll inform Brandon of our decision, and he will let both of you parties know.
Much appreciated.
Thank you
guys
very
need
much.
these extra packets?
I don't think
No.
so.
No.
Okay.
Do you want one for the deliberation?
We could share one. I mean, we can share. Yeah, we're fine, thank you. Okay, I believe meeting is adjourned. No? What else? Okay. Recess, or do we?
You don't want to, you don't need to come back on record for anything, so you can adjourn.
Right, we can
closed
adjourn
session.
now, and we just give our decision.
So time is 4:05 PM and the meeting?
Meeting is adjourned. All right.